So let's go with Trish Rifo and the ABA, which is very important.
Hello, I'm Trish Rifo, President of the American Bar Association. Before we begin the rest of today's program, I'd like to thank the New York State Bar Association International Law Section for organizing this conference with support from co-sponsors, including the American Bar Association Section of International Law. Meeting today, we advance a critical goal to ensure the very survival of our world, and that is to insist on the central role of the rule of law in the governance of nuclear weapons. The legal profession is strengthened by the ABA's dynamic relationship with the New York State Bar Association and other organizations that lead on the important issues of our day, issues where thoughtful and committed lawyers can and do make a difference. Speaking before the UN General Assembly in 1961, President John F. Kennedy famously said that, quote, "Every inhabitant of this planet must contemplate the day when this planet may no longer be habitable. Every man, woman, and child lives under a sword of Damocles, hanging by the slenderest of threads, capable of being cut at any moment by accident or miscalculation or by madness. The weapons of war must be abolished before they abolish us." After the Cuban Missile Crisis of 1962, the intelligence agencies of both the United States and the then Soviet Union concluded that without a legal constraint, a cascade of nuclear proliferation was likely, and thus they committed to advancing a path to curb proliferation and advance disarmament. In 1970, under the presidency of Richard Nixon, the Nuclear Non-Proliferation Treaty entered into force. I am proud that the ABA House of Delegates resolved to support the indefinite extension of that treaty in 1995. Among today's panelists is the distinguished U.S. diplomat who led the negotiations of that accomplishment, Ambassador Thomas Graham. Ambassador Graham is a member of the ABA International Law Section's Task Force on Nuclear Proliferation. The ABA also supports the Comprehensive Nuclear Test Ban Treaty, for which Ambassador Graham was also a central figure. The ABA's leadership in this area is part of our broader commitment to pursue international stability and order based on the rule of law. We act on our commitment with the hard work of our Task Force on Nuclear Non-Proliferation and many other committees that focus on bringing about a safer and more secure world, not through the law of power, but through the power of law. The American Bar Association, the world's largest, most prominent organization of legal professionals, stand firmly for advancing the power of law to control, constrain, and eliminate nuclear weapons. Thank you, all of you, for your contributions and your commitment to protecting all the world's inhabitants by advancing justice, security, and liberty for all. The American Bar Association stands with you.
Okay, well, that was wonderful. John Burroughs is the moderator of our next panel, which John will tell you about.
So this is panel 4, International Law and Threat and Use of Nuclear Weapons. I'm John Burroughs, Senior Analyst, Lawyers Committee on Nuclear Policy. We have on this panel Charles Moxley, Charlie, Kathleen Lawand, and David Koplow. I'll introduce them as they come up. And first, it will be Charlie Moxley. And so he's, among other things, he has his own arbitration mediation organization. He's an adjunct professor at Fordham Law School. He's a distinguished ADR practitioner in residence at Cardozo Law School. He is the author of the book, Nuclear Weapons in International Law and the Post-Cold War World. And not least, he's a member of the board of directors of Lawyers Committee on Nuclear Policy, my organization, and he conceived of and co-organized this conference. Charlie.
Thank you. Thank you. Thank you very much. This has been a wonderful day. Now we come after a lot of introduction as to rule of law and the commitment of the State Bar and the ABA to rule of law. And now we're going to come down to actually talking about it. The particular area of international law that we're going to focus on now, and of course the topic is considerably broader than this, but the central area that we're going to focus on now is the law of armed conflict. And as I mentioned earlier, the term law of armed conflict is essentially synonymous with law of war and international humanitarian law and the old Latin jus in bello. And it's essentially the regulation of the use of force within war, within armed conflict. Now, the first point to note is that it is totally not controversial. It is agreed by the United States and by all the other countries, nuclear weapons countries across the board, that the law of armed conflict applies to nuclear weapons as well as to conventional weapons. We can question the premise whether that is enough and whether indeed we need another level of law that specifically addresses nuclear weapons. And we'll get to that today if we can. But for present purposes, we're going to look at the law of armed conflict as applies to all uses of force in armed conflict. And I will say that the approach I've taken in my book, in the article that John Burroughs and Jonathan Granoff and I did together some years ago that's in the materials, is in order to take out of reasonable disputation what the law is, I've taken it from essentially statements by the US military and the US before the ICJ and other statements by the US as to the law of armed conflict. So first point, this part is not controversial. The basic rules that I'll talk about, and I'll try to be quick because I have limited time, are the rules of distinction, proportionality, and necessity, and their corollary, the rule of controllability, the requirement of controllability, and the rule of precaution. And so what these rules require, as I said, is, and I'll state the rules, not controversial at all. Where the rub is, and where the proponents and the opponents of the lawfulness of the threat and use of nuclear weapons disagree, is on how you apply these rules to the use of nuclear weapons. And I'll state at the outset that that is a very major point. Professor Scott Sagan from Stanford, and I'm delighted, Scott, you're still with us, made the point earlier that the JAG folks represent a huge law firm and are all over this issue. And I'll say that that is certainly my understanding, that there are broad statements from the US military and the US government as to the law here and as to the commitment of the US to follow the law of armed conflict as concerns nuclear weapons. Where the rub is how they apply it. And I'm just going to give as a premise that if they're misapplying, if the application of the applicable principles is misguided by the U.S. attorneys who are leading our legal analysis of these weapons, then their conclusions are misguided. And the gravamen of my remarks here is that there's reason to question whether we don't need to look more deeply at the requirements of international law, and that they're not more demanding than the U.S. Legal community within the military recognizes. Okay, so that's the thesis I'm going to try to present. The first rule I mentioned is a rule of distinction or discrimination, that in the use of force, and I'm actually reading from a military manual, This one is a 2010 Army Manual on the Law of Armed Conflict, desk book, that parties to the conflict shall at all times distinguish between the civilian population and combatants, and between civilian objects and military objects. So that's the rule of distinction, right? You need to be able to distinguish. So if we look at that in a straightforward way, it's a straightforward question of when we use a particular weapon, can we distinguish? A number of the speakers mentioned that the U.S. has moved towards, at times, what's called war fighting, that we're not doing mutual assured destruction. We're not aiming at civilians, we're aiming at military targets. But there is that issue of co-location, and it's not controversial. I believe it's broadly recognized that the contemporary concept of the breadth of legitimate military targets is such that there are military targets around cities in the US, major cities, major urban centers, and in Russia and in other countries of the world. So we still end up, so the question is, when we use a nuclear weapon, even directed at a military target, can it distinguish the non-military, the civilians, persons, and objects in the target area? So that's a huge question, and it's a serious one, right? Because the fact is, I would submit that in most, if not all situations, certainly of any use of large-scale nuclear weapons, and we'll talk about low-yield nuclear weapons separately, that it's hard to imagine circumstances where there will be a real distinction between the military and civilian targets, unless you hypothesize really remote targets, a submarine at sea or way out in the desert or a remote missile field. But that's the first level. The way it appears that the U.S., the internal legal community, as I understand it, has looked at this issue, is to look at, can we hit the target? And my thesis here is that that's not adequate. It is true that we're much better at hitting targets now. Our accuracy is extraordinarily good on a statistical basis, although there will still be weapons that go awry. This is something Scott Sagan and I have discussed about, well, you have the CEP within which the weapon will hit, but what about the ones that don't? But there is a lot of accuracy now, although the failure of accuracy, which is inevitable, is much more serious, obviously, with a nuclear weapon. But the real point, I suggest, is to say that the issue for distinction is, can we distinguish, can we hit the target, really misses the rule, because the rule says that can we distinguish between the military and civilian aspects of a target. And to consider this, is it not clear that we should consider all the effects of nuclear weapons, not just hitting the target and blowing it up and the heat and blast there and the prompt radiation, but also the inevitable? It is inevitable. It would be an oxymoron to have a nuclear weapon that didn't have radiation. There's going to be inevitable radiation with a high burst, a high height explosion. We haven't talked about this much, but there's electromagnetic pulses which can destroy electronic communications on the ground over extended areas. There's nuclear winter, as a number of the speakers have talked about, and there are studies. I think Governor Brown referred to it, if I recall correctly, where just a relatively small number, some 30 weapons back and forth between the US and Russia, India and Pakistan, could precipitate nuclear winter. It's huge amounts of soot thrown up in the air that block out the sunlight, and so you have the effect on agriculture and on human life as a follow-up reverberating effect of nuclear weapons. So on the principle of distinction, the point I'm making is it's not enough to hit the target, but that the other inevitable, known, unavoidable aspects of the nuclear strike, including the radiation and the potential and the electromagnetic pulse and the potential for nuclear winter, have to be considered. The other question is, do we have to consider the potential for a nuclear response and for escalation. And in a sense, it seems illogical that we would, because that's done by somebody else. But this is why we have spent so much time in this program on the nuclear policy, because we know that there is a high potential for a nuclear response if you have nuclear weapons countries get into a conflagration. And so if you're going to have an escalation and if you're going to have compounding effects, are they not would have to be considered. The second main rule of the law of armed conflict that I'm going to focus on is the rule of necessity. And I believe it was Scott Sagan who referred to this earlier and said that, if you can do a particular strike with a conventional weapon, then you should, because it's not necessary to use a nuclear weapon. And if you use one, you could take it down to a lower and lower level. So the principle of necessity makes us go to the lowest level use. That's why in the questioning about the effects of nuclear weapons, we focused on the revolution that has taken place in conventional weapons, because they have gotten so good, they have gotten so accurate. If you can hit a target, as has been mentioned, right on the head, on the nose, as opposed to being able to hit it a half a mile or a mile and a half out, obviously you need much less firepower. And we're getting towards this prompt strike capability to hit any place in the world with high power conventional weapons within an hour, and it may soon be within a half an hour. So the point was made earlier, well, you may need to use several conventional weapons for these situations, but the conventional weapons don't carry the same risk, right? They will carry huge risks of huge casualties, but not the ongoing risk that Professor Arakaki told us about that go on for generations, not the radiation, not the electromagnetic pulse, not the nuclear winter. So the rule of necessity, we often hear, and this, those of us who have been doing this for years, this focus on low yield nuclear weapons, this happens every, I can't tell you exactly, 10 or 15 years. And somebody says, and it goes back to the 60s and the 70s, I believe, somebody says, well, deterrence isn't credible that we'd actually use these hundreds of kilotons or even megaton nuclear weapons. So let's go to the low yield, because they're more credible and more lawful. But are they really? Not really, I suggest, because if you can use the conventional weapons, and we heard various numbers, I submit using multiple conventional weapons, that it's going to be rare targets. There may be some, that's an issue where, and there's various ways to address targets other than blowing them up. But for a huge percentage, it seems now, of potential targets of the US, there is a potential to address them with conventional weapons. So that's a huge point. The same thing on the risk of proportionality, which is the requirement that there be some reasonable proportionality between the military value of a target and the level of collateral effects that you're going to have. Again, at the first level of analysis, whether a nuclear weapons use or many nuclear weapons uses could comply with proportionality seems questionable, right? If you're using a nuclear weapons against a military target that's co-located with civilians, it's near a city, it's near urban areas, or it's close enough that there's a risk that you're going to hit urban areas, it's going to be very hard to comply with the proportionality. Now, there are hypotheticals where you talk about hitting a remote target at sea or in the desert or a missile base in the mountains someplace, where you get down to the question of, well, maybe that could fit within proportionality, right? Because maybe there's you're going to take out a lot of missiles. So maybe you could satisfy proportionality there, but can you satisfy necessity? Can you satisfy other requirements? But this is, again, looking at proportionality only vis-a-vis the direct effects of nuclear weapons. It appears to be the case, and I assume we'll get to this in the discussion part, And I think this is something David Koplow, having been in the government, knows a lot about. But to my understanding, the U.S. military and our planning for nuclear strikes, this legal analysis that we've been told that the JAG officers do and so forth, doesn't encompass. We haven't, to the best of my understanding, modeled and addressed potential radiation effects, electromagnetic pulse effects, nuclear winter effects, nuclear retaliation, nuclear escalation effects. We're not adequately considering that. And so this leads to a sense that I'm projecting as a thesis that it is very hard to see how nuclear weapon strikes could comply with any of these three rules of the law of armed conflict that I've mentioned. But there's a further point that to me is most central here, and that is that if one reads in the US military manuals and the statements of these rules, how the rules are formulated, it is very clear in the US's own definition of each of these rules that a weapon has to have its effects be subject to control for the US, and of course this applies to other nuclear weapons countries, to know that the weapon effects can be controlled and assessed to assess whether the use of the weapon will comply with the law of armed conflict. If the weapons are not controllable, then the use of these weapons can never, I present as a thesis, comply with the law of armed conflict, international humanitarian law. And I submit that the effects of radiation and electromagnetic pulse and nuclear winter, among others, have to be considered because they're known, inevitable, foreseeable effects, and they're simply not controllable. Even with low yield nuclear weapons, the radiation, and there are statements of this, will come from even low yield nuclear weapons, and it's subject to weather conditions, climatic conditions, a lot of factors that can't be controlled. Now, a fourth rule, and John, you'll cut me off if I get at the point where I need to stop.
You should stop in a couple of minutes, Charlie.
Okay, a fourth rule is a rule of precaution, which is a rule of the law of armed conflict that requires that states take all reasonable measures to train their people and control their equipment so as to be able to comply with the law of armed conflict. But the US is on this high alert that we've heard about today, where some 900, I think Dr. Christensen said, of our nuclear weapons are on instant alert, and Russia is the same, and some other nuclear weapons countries are the same. We have this high alert level, and we have this launch on warning that in theory, we will respond to an incoming attack before it lands. So the time factor that the experts tell us, and this has been alluded to, that the executive would have and the military would have, is 10 to 30 minutes. So because of this high alert status, we haven't given ourselves time to do a reasonable analysis. And that's not necessary. Other countries, China, for instance, has a policy that's more conservative here, to a large extent separating out their weapons, not having them on high alert, giving themselves time. So one final point I'll just make in 2 minutes, John, if that's okay, is the area of risk analysis. In theory—
Charlie, why don't
Yes.
you hold that for discussion?
Okay, fair enough, John.
I think
Yep.
that's
Yep.
certainly worth talking about. So let me introduce Kathleen Lawand. She's currently strategic advisor to Director of International Law and Policy, International Committee of the Red Cross. And from 2012 to 2020, she was head of the arms unit in the legal division of the ICRC. And there she oversaw the development and promotion of the ICRC's legal and policy positions on weapons of humanitarian concern. In that connection, I saw her in action at the 2017 negotiation of the Treaty on the prohibition of nuclear weapons. Kathleen?
It looks like you're muted, Kathleen.
You're muted, Kathleen.
No, we still can't hear you. We might be having some audio issues.
Can you speak, Kathleen? Well, we lost Kathleen for a moment. So Charlie, why don't you talk about risk analysis?
Okay, I'll do it quickly because everybody's got a lot to say, and I want to hear the other speakers as much as everybody else does. The point about risk analysis is that by hypothesis, and everyone knows this intuitively, we need to evaluate the lawfulness of the use of weapons in military operations in advance. I mean, that's in theory, and we have war rooms. The U.S. has shown a demonstrated commitment to LOAC in recent years in its current military engagements, and has JAG involved and so forth. But this analyzing things in advance is particularly important as to nuclear weapons because the consequences are so extreme, right? I mean, that's obvious. So the question is, how do we do this? How do we analyze potential risks? And I see Kathleen is here, so I would wrap this up quickly. How do we do it? Now, there are a lot of ways of analyzing risks, but the Joint Chiefs of Staff of the U.S. military have a manual on joint risk analysis. And there are a number of articles by military people who speak at West Point and who are very authoritative. And the bottom line appears to be that the U.S. generally, this is a policy that's general, and it's not specific to nuclear weapons, but it includes nuclear weapons, says what we need to look at is all foreseeable risks. That's the theory. That's the chapter and verse. And so we need to look at the risks and assess them in terms of the operational desirability of this particular military strike and weapons use, and also in terms of its compliance with LOAC IHL. So there you go. So this means looking at the percentages and the values for each of the potential risks. So the final thing I'll leave you on this, the most vexing question is, should the JAG people who do this work evaluate a low probability risk of an apocalyptic and extreme effects? I mean, something involving tens or hundreds or even more millions of people. How do we evaluate that in an operation that looks potential, but there's a percent, a couple percent, a 0.5% risk of existential effects in terms of how the thing will play out. So I leave that question there, and Kathleen, I'm glad you're back.
Can you hear me now?
Yes,
Yes.
we can hear you.
Wonderful, wonderful. I'm glad to be here. I apologize. I've been having technical difficulties. I'm speaking to you from my phone now, and apologies. I had to make some manipulation to make the microphone work. I'm not very technically inclined for these things. Thank you so much, though, for inviting me. And a special thanks to the New York State Bar Association International Section for organizing this important event. I'm really delighted to be here. I will be providing the perspectives of the International Committee of the Red Cross on the compatibility of nuclear weapons with international humanitarian law, IHL, the law of armed conflict. I agree with much of what Charles has said on this. I will bring a slightly different perspective. But perhaps I will start by way of introduction by explaining why it is the ICRC has been so engaged on this issue of nuclear weapons and has been calling for the prohibition of nuclear weapons. We first called for nuclear weapons to be eliminated in September 1945, after witnessing firsthand the horrific consequences of the atomic bombing of Hiroshima. where alongside the Japanese Red Cross, we attempted as best we could to assist the dying and wounded. So we were there 75 years ago. And this experience left, and it marked us profoundly. And in the next 7 decades, the ICRC and the broader International Red Cross and Red Crescent movement, of which the ICRC is a part, has regularly repeated this call. And in March 2010, over 10 years ago, and this was shortly before the NPT review conference, the president of the ICRC issued a historic appeal to states to urgently take measures to prevent the use of nuclear weapons and to negotiate a legally binding international agreement to prohibit and eliminate them in accordance with existing commitments and international obligations. And our movement echoed this appeal 1 year later in 2011 in, again, a historic resolution. And our appeal was based on 3 observations. First, the catastrophic humanitarian consequences of any use of nuclear weapons. And this was based, as I said, on our firsthand experience. And our firsthand experience also include the long-term impacts of nuclear weapons on human health, that due to radiation exposure, because the Japanese Red Cross to this day continues to treat, they're very few in number today, but continues to treat persons who were exposed to nuclear radiation 75 years ago as children from cancers and other diseases, and have been doing so for the last 75 years. The second observation is the lack of any adequate humanitarian response capacity, nationally or internationally, in case of use of nuclear weapons. And as a major global humanitarian assistance movement, this is very much of concern to us. Our studies show we would be incapable of providing adequate humanitarian response in case of use of nuclear weapons. And then the third observation, critically, was our conclusion that it is difficult to envisage any use of nuclear weapons that would be compatible with IHL, international humanitarian law. The ICRC was therefore heartened that in 2010, the NPT review conference expressed for the first time its deep concern at the catastrophic humanitarian consequences of any use of nuclear weapons, and it reaffirmed the need for all states at all times to comply with international law, including IHL. Nuclear weapon states parties also committed to accelerating progress on the steps leading to nuclear disarmament and to undertake further efforts to reduce and ultimately eliminate all types of nuclear weapons. Yet, as we know, there has been little progress to implement the NPT's disarmament obligations and commitments. The ICRC and the entire Red Cross and Red Crescent movement therefore welcome the 2017 Treaty on the Prohibition of Nuclear Weapons, the TPNW, or Nuclear Ban Treaty, which comprehensively prohibits nuclear weapons, notably on the basis of IHL. And the treaty's preamble is very clear about this. Indeed, the 9th preambular paragraph provides that states parties to the treaty are, and I quote, basing themselves on the principles and rules of international humanitarian law, in particular, the principle that the right of parties to an armed conflict to choose methods and means of warfare is not unlimited, the rule of distinction, the prohibition against indiscriminate attacks, the rules on proportionality and precautions in attack, the prohibition on the use of weapons of a nature to cause superfluous injury or unnecessary suffering, and the rules for the protection of the natural environment. In a few seconds, I will outline some of the issues raised by nuclear weapons under some of these rules, building on what Charles has just mentioned. I would just mention that all of these rules are of customary law binding on all states, in addition to be codified in additional Protocol 1 to the Geneva Conventions. I'd like to mention as well that preambular paragraph 9 of the TPNW goes on to say that any use of nuclear weapons would be contrary to the rules of international law applicable in armed conflict, in particular IHL. So there's this very categorical statement in the preamble of the TPNW that any use of nuclear weapons would be contrary. not generally speaking, but would be contrary to the rules of international law applicable in armed conflict. I should mention that at the time of the treaty's negotiations, some states, such as Sweden, expressed the view that this provision does not reflect current international law, preferring instead the International Court of Justice's formula that nuclear weapons are generally contrary to IHL as the correct statement of the law. I will not pronounce on this debate. Instead, I will look at what we believe are the major challenges to demonstrating a use of nuclear weapons that would be compatible with IHL. Today, the TPNW is the only treaty at global level to comprehensively ban nuclear weapons. But from a strictly legal standpoint, when the treaty enters into force, it will be legally binding only on those states that have formally adhered to it through ratification or accession. Therefore, the question of the compatibility of nuclear weapons with the general rules of IHL covering the choice of all means and methods of warfare remains relevant. And it is important, of course, to recall, and I think others have done before me, that the ICJ confirmed in the nuclear weapons case that the lawfulness of any weapon can be assessed against these general rules, distinction, proportionality, precautions, etc., and that nuclear weapons are no exception in this respect. It should also be recalled, and this is critical, and I will end my remarks with this in a few minutes, I'll come back on this, that IHL must be respected at all times, whether in offensive or in defensive operations. There's no exception in extreme cases of self-defense for respecting the obligation to respect IHL. Now, for legal practitioners, the starting point for assessing the compatibility of any weapon with IHL is, of course, the facts, the evidence of the weapon's foreseeable short-term and long-term effects on civilians, on human health, and on the natural environment. Charles mentioned the rule of distinction, that is the requirement to direct attacks against a specific military objective. I will skip over this, therefore, and turn instead, also given the shortness of time, to the prohibition of indiscriminate attacks. So an attack is indiscriminate if it is of, and now I'm quoting from the rule as stated in Additional Protocol 1 and similarly under customary law, an attack is indiscriminate if it is of a nature to strike military objectives and civilian objects without distinction, either because it is carried out using a weapon that is incapable of being directed at a specific military objective, or the weapon's effects cannot be limited as required by IHL. That is, the weapon's effects escape the control of the user in time or space. So even admitting that a nuclear weapon can be directed at a specific military objective, for example, because it's fitted with precision guidance, a key issue remains whether the forces released by the nuclear detonation and the effects of those forces can be sufficiently limited to the target. We know that a nuclear detonation releases a combination of powerful blast waves, intense heat in the form of thermal radiation, high amounts of ionized radiation, which in most cases will be dispersed over very wide areas. The heat generated by the explosion may trigger intense fires and firestorms, the effects of which are uncontrollable. We've talked also about the impact of radiation and residual radioactive particles, so-called nuclear fallout, created by the blast, likely to spread far beyond the target area, potentially over great distances and across borders. So it seems therefore clear that there would be inherent difficulties in controlling or limiting the effects of nuclear weapons in space and in time. And these uncontrollable effects would indicate an attack striking military objectives and civilian objects without distinction. And this is especially the case if nuclear weapons are used in or near a populated area. And we would submit, the ICRC would submit, that arguably this would mean that the use of a nuclear weapon in or near a populated area would in all cases constitute an indiscriminate attack. It can also reasonably be concluded that the use of a nuclear weapon in or near a populated area would violate the rule of proportionality in attack, as Charles indicated. This rule requires that for an attack against a military objective to proceed, the expected incidental or collateral civilian casualties and or damage to civilian objects must not be excessive in relation to the concrete and direct military advantage anticipated. That's a direct quote. To be clear, the advantage must be military, it must be concrete and direct, and it must not be remote, long-term, or hypothetical. What does this mean? Well, this means that the overall objective of winning the war or defending the nation is too broad for the purposes of this rule and does not qualify as a concrete and direct military advantage under the law of armed conflict. It is therefore clear that any use of nuclear weapons in or near populated areas would have severe and extensive immediate and long-term direct and indirect consequences for civilians, which are today entirely foreseeable given what we know about the effects of nuclear weapons. So these rules just have very briefly looked at how IHL protects civilians from indiscriminate harm, from disproportionate harm. Now, what about protection of combatants? Because of course we've talked about the scenarios of using a nuclear weapon in remote areas, in a desert, for example. Is it lawful to use a nuclear weapons against combatants, against enemy combatants massed in a desert, for example? Well, we would see a major impediment to that under the prohibition of weapons of a nature to cause superfluous injury or unnecessary suffering. This rule refers to injury suffered that is in excess of what is required to achieve the legitimate military goal sought. It aims to protect combatants, and compliance with this rule is assessed by reference to the weapon's designed injury mechanism, that is, its effects on human health. And clearly, as has been described, the horrific short and long-term illnesses, permanent disability, and suffering caused by radiation exposure raises serious questions about the compatibility of nuclear weapons with this rule. And then finally, we can mention rules aimed at protecting the natural environment. And I will go over this quickly for want of time. IHL customary law, customary rules of IHL aimed at protecting the natural environment require that all means and methods of warfare be employed with due regard to the protection and preservation of the natural environment. And there again, given what we know about the potential impact of radiation and the destructive nature of nuclear weapons and the long-term impacts of radioactive particles, et cetera, on the natural environment, there are major questions to be asked whether this rule could be respected. IHL also prohibits the use, but this is not a rule of customary law for the reasons I'll mention in a second. IHL also prohibits the use of means and methods of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment. And these rules, which are codified, this rule rather, which is codified in Additional Protocol 1 to the Geneva Conventions, has not become part of customary law with regard to nuclear weapons because a number of states have consistently objected to its application to nuclear weapons. And unsurprisingly, these are nuclear weapon states who have objected to the customary law codification of this rule. Nonetheless, the potentially severe immediate and long-term effects on the environment and certainly, even if there's, in the case of an even limited nuclear exchange, raise significant questions on the rule, given what we know about the major long-term disruption to climate and the severe food insecurity that would be created for up to 1 billion people, even from a limited nuclear exchange involving just 100 nuclear weapons. So I will conclude my remarks with this on the notion of self-defense. By reference to the advisory opinion, the 1996 advisory opinion of the International Court of Justice, where the ICJ concluded that the use of nuclear weapons would generally be contrary to the principles and rules of IHL. However, the court stated that it was unable to decide whether such use would be lawful or unlawful, and I quote, in an extreme circumstance of self-defense in which the very survival of a state would be at stake, end quote. In this respect, the court did not conclude that the use of nuclear weapons would be allowed in an extreme case of self-defense. Rather, it indicated that in the state of international law and the facts at its disposal at the time in 1996 did not allow it to reach a definitive conclusion. For our part, the ICRC considers that the exercise of the right of self-defense, even in an extreme situation where the very survival of the state is at stake, can on no account release that state from its obligations under IHL. In other words, there is no suspension of international humanitarian law in cases of self-defense. If this were the case, this would amount to the ends justifying the means and spell the end of law. This is very much about the rule of law and the rule of universal humanitarian principles, which are a critical underpinning of the world order. Self-defense must be exercised in compliance with IHL, whatever the circumstances, and not in violation of the very rules intended to mitigate the suffering caused by armed conflict. And these age-old rules that aim to impose limits on what is permissible in warfare. So to conclude, it is indeed very difficult to reconcile nuclear weapons with IHL. Thank you very much. And sorry, I think I spoke a bit longer than I was meant to. Thank you so much.
Thank you, Kathleen. I'm really delighted you were able to join us. And, not everybody may know that the International Committee of the Red Cross is a leading authority, or perhaps the leading authority on international humanitarian law. And I've delved many times into their 2-volume and thick volume study of customary IHL. So our next speaker is going to be David Koplow, who's a professor at Georgetown Law. Among other governmental positions, he served from 2009 to 2011 as special counsel for arms control to the General Counsel of the U.S. Department of Defense. He has published 5 books and numerous law review articles regarding treaty negotiation, verification, and implementation, and regarding the intersection between international legal standards and U.S. constitutional law. David.
Thank you, John. And let me extend my congratulations to you and Charlie and Jonathan and to everybody else who's been involved in assembling and presenting this truly extraordinary day-long program. It's a real treat to watch and to listen to extraordinary presentations by such a wide group of distinguished experts. And I'm delighted to participate. And I'm delighted to see that the program has attracted a large audience, and an audience, as you can see from the list of participants, with substantial expertise. So I look forward to the discussion that we'll be able to have at the end of this program and later in the day. I thought that for my presentation on this, I would focus on one particular legal tool that I think has a lot to say about the international law applicable to the possession, threat, and use of nuclear weapons. And that is the 1996 decision, the advisory opinion by the International Court of Justice. Although this decision is now almost 25 years old, it remains a primary source for study of the legality of nuclear weapons for 2 kinds of reasons. First, this is, I think, the most authoritative, thoughtful, expert, widely acknowledged source. The International Court of Justice is entitled to great deference and respect for the work they've done in this matter. Secondly, this decision is maddeningly incomplete, incoherent, internally contradictory, and confounding for further analysis. So I'd like to pick at what the ICJ said in that decision, and I'll apologize in advance if some of my remarks have more the tone of a long-winded rant rather than a careful academic presentation, because this gives me the chance to get off my chest some points that I've had in mind for a long time. The ICJ began, I think appropriately, by determining that nuclear weapons are fundamentally weapons. They are unusual weapons, both in terms of the devastating power and the extraordinarily long-lasting effects, but they are weapons, and therefore they are governed by the traditional law of armed conflict, international humanitarian law, that applies fully to all other weapons just as much. It takes some special analysis and handling, but fundamentally, the rules as articulated by both Charlie and Kathleen on proportionality and necessity and avoiding unnecessary suffering apply to nuclear weapons as they do to all other circumstances. And in evaluating the effects of nuclear weapons, the advisory opinion concluded that nuclear weapons are scarcely reconcilable with the fundamental principles of international humanitarian law. But the court determined that it could not say categorically that in all circumstances, any use of nuclear weapons must be a violation of international law. By the narrowest of margins, essentially an 8-7 decision, the court decided that there might be some scenarios in which the threat or use of nuclear weapons could be lawful despite the unusual effects and power that the weapons might have. And I'd like to zoom in on those two, on a couple of the circumstances under which the court hypothesized that the use of nuclear weapons might nonetheless be legal. And again, here you have to acknowledge that the court is not completely clear in setting out its logic or the fact patterns they were concerned with. It requires some interpretation, some interpolation. But I think we can identify at least two categories of cases. The first concerns the possible use, as suggested by one of the states participating in the proceedings, possible use of a small number of very low nuclear weapons against a military target that was located at a long distance from population centers. And here the scenario might be use of weapons against a naval fleet on the high seas far from shore, or perhaps a use of nuclear weapons against a column of tanks on the desert someplace distant from population centers. And the court concluded there that the use of a small number of very low yield weapons in those discrete circumstances might be such that the effects could be confined, could be controlled, could be limited in a way that would be compatible with international humanitarian law. And my reaction to that is, first, that if this were a law school exam, I might have to give the ICJ a pretty good grade for having come up with a scenario, hypothetical, that meets some of the legal standards and that might dodge the applicable prohibitions and imagine a lawful use. But I think we should expect more than that from the World Court, because the court's decision here ignores the fundamental reality about how the United States and the other countries that possess nuclear weapons have built and designed their arsenals, the strategic doctrines that underpin their potential use, and the testing and training that accompanies the nuclear programs. In fact, the US does not have an arsenal that is, US and the others do not have arsenals that are optimized for that small scale, limited, remote use. Instead, the United States has large nuclear weapons. We've got some small ones too, and I'll return to that point in a moment. But fundamentally, the arsenal in the United States and elsewhere includes large nuclear weapons that are an order of magnitude bigger than the weapons that were used with such devastating effect on Hiroshima and Nagasaki at the end of World War II. And the scenarios for use do not involve using only a very small number. They involve massive uses of nuclear weapons. They do not involve principally targets that are remote from population centers. Instead, the weapons, the arsenal, and the doctrines for use focus upon the possibility of using them against military targets that are located in or near population centers in Russia, China, and elsewhere around the world. So the And the forces are trained with that sort of big uses in mind. So while it may be possible to construct scenarios where a nuclear weapons use might be legal, that's not the reality. That's not what the world of nuclear weapons today is all about. And the ICJ could and should have done better. And to illustrate this, I'd like to offer an extended analogy. This does take a moment, so please bear with me, but I think I can connect it back up. The analogy is to the world of chemical weapons. And chemical weapons are another tremendously important and deadly device that the New York State Bar Association could well put on a day-long program about those at some other time. But for now, the point is just that there's a treaty that deals with chemical weapons, the Chemical Weapons Convention, that constitutes a comprehensive and nearly universal prohibition against the wide range of chemical weapons activities. It restricts countries from manufacturing and possessing and testing and selling and using chemical weapons categorically. But there's a problem, because many chemicals are dual use or multi-use in their nature. The same sorts of precursor chemicals that, when combined to make new, chemical weapons, they're also used across the entire array of the civilian economy for all sorts of benevolent purposes, from plastics to paints to fertilizers to insecticides. And you just could not, as a practical matter, ban all of those toxic chemicals. Even though if you combine them in one way, you get fertilizer and insecticide, you combine them in another way, you get nerve agent and mustard gas. So what the treaty does is to permit the possession of those toxic chemicals where they are used for purposes not prohibited by the treaty, where they're used for peaceful industrial or agricultural or pharmaceutical use. You can retain those chemicals, but the treaty says you can retain those chemicals only when they are in types and quantities that are consistent with the peaceful use. So you can't lawfully retain huge quantities of toxic chemicals and say, well, we're going to use these for insecticide, when they're not quite the right chemicals that we'd use for insecticide, and you're not holding them in quantities that would be appropriate for that use. You can use chlorine for swimming pool and for purifying drinking water, but you can't hold vast quantities of chlorine that would be incompatible with that use. It seems to me that's the concept that the ICJ could and should have used in dealing with the legality of nuclear weapons in this remote possibility. What they could have said is that the possession and use of nuclear weapons might be lawful when you might use a small number of low-yield weapons in a remote circumstance, but that's the only way that you can possess nuclear weapons. You can't possess large arsenals of large numbers of nuclear weapons and announce a strategic doctrine and do the testing and training that would be appropriate for other kinds of uses. If only a small number of low yield weapons would be legal, that's the only kind of weapons you could possess. The ICJ could have said that and did not. Now, I mentioned that the United States does possess a number of low yield nuclear weapons. And here it seems to me that the ICJ decision, the advisory opinion, has perversely led the world, reinforced the world's movement in precisely the wrong direction. That is, many military authorities in the United States and elsewhere have sought to pursue low-yield nuclear weapons precisely because they would be more usable. The argument is that very large nuclear weapons are so powerful and so destructive that we would be self-deterred from using them in ordinary circumstances, but that as a warfighting technique or tool, it'd be better to have low-yield nuclear weapons. And the ICJ decision seems to reinforce that instinct. To me, that's precisely wrong. The world should not be seeking low-yield nuclear weapons. We should not be seeking nuclear weapons that are more usable. We should seek to make the barriers against any use of any nuclear weapons as high as possible to preclude any possibility of any use of nuclear weapons. The ICJ decision in seeming to endorse this one scenario, I think takes us in the wrong direction. So that's one scenario where the ICJ decision endorsed the possible legality of the use of nuclear weapons. The other, as Kathleen highlighted at the end of her remarks, is in some ways the opposite scenario. The ICJ determined that nuclear weapons use might be legal in an extreme circumstance where a country's sheer national survival was at stake. And again, they weren't completely clear as to what they meant by that, but it appears that this was a nod in the direction of the doctrine of deterrence, a doctrine of mutual assured destruction that many people would say gets some of the credit for preserving the world against the possibility of a World War III, against the possibility of having used nuclear weapons, not since 1945. And I don't want to debate today the validity of the doctrine of deterrence and determine exactly how much credit should go to the doctrine of deterrence. But as a legal matter, it seems to me here that the ICJ has the analysis exactly wrong. The nuclear weapons are governed by the law of armed conflict as all other weapons. The use of nuclear weapons, even in a circumstance of national survival, is part of the law of armed conflict. The law of armed conflict does not have exceptions that say the law does not apply when there's a lot at stake. It does not apply when you might be in danger of losing the war. It does not apply when the stakes are very high. The law of conflict, the law of armed conflict applies at all times during an armed conflict, including when the stakes are at their highest. There are some things that are just categorically impermissible, even if you think you might gain some military advantage from doing them. You can never torture prisoners of war. You can never deliberately aim at civilians. You're never allowed to undertake attacks that are disproportionate, even if you think your national survival is at stake. So again, it seems to me that the ICJ attempting in some plausible way to acknowledge the importance of the doctrine of mutual assured destruction and to acknowledge in some ways the continuing viability of the deterrence relationship as the centerpiece for nuclear security around the world today. The doctrine that they've declared, I think, is a mistaken one. Well, I think that's probably where I should stop. There's more to be said, but I look forward to pursuing that in the discussion with the rest of the panel. Thanks.
All right, well, thank you, David. So I'm not sure that all the panelists heard discussion earlier today, but we learned something from Scott Sagan in particular about how the US military is approaching the application of IHL in the nuclear context, and also that it's now declared policy and has been for a number of years that US use of nuclear weapons will comply with IHL. So here's how, this is going to be a question eventually. Here's how I understand the US military lawyers approaching this. That a use of nuclear weapons has to comply in particular with requirements of necessity, proportionality, and distinction. However, the requirement of distinction is interpreted rather narrowly, that the targeting must be against military targets. If you're not deliberately targeting civilians, then you're not violating the principle of distinction. So it appears to me that in effect, they've read out of the picture the prohibition on indiscriminate attacks that Kathleen talked about. And I believe there's a procedure within the US government whereby weapons are inducted into the stockpile and they're not inducted if they're considered to be inherently indiscriminate. Well, nuclear weapons have been inducted, so they weren't considered to be inherently indiscriminate. And Charlie discussed quite clearly the requirement of necessity, but on proportionality, Kathleen, you know, I think one can imagine circumstances where it could be argued that the requirement of proportionality is met. If you think that the enemy is about to launch an attack on your cities, you might think that collateral effects, killing or injuring tens of thousands or even hundreds of thousands of civilians near the target might be proportional. You know, I think that's the kind of grim calculus that comes into play here. So let me ask the question of our panelists, assuming that I've more or less correctly described how the US military approaches the question of use of nuclear weapons, how would you assess that? How would you comment on it?
John, I think I'd say that, you know, there's plenty of stuff in the US military manuals against indiscriminate attacks, and the US manuals acknowledge the point that Kathleen made. I mean, it's right there that you can't use a weapon if you can't control the effects of it. It does seem to me, and I don't know, David, if you have a fix on this, but the sense I have is that the flaw here in how the military is evaluating this and how the US can say that these weapons are lawful is by curtailing the analysis to only be very focused on a narrow view of the potential effects. So, you know, without considering the radiation in nuclear winter and without considering the potential for a nuclear response and escalation, which would apply even to the remote use. I mean, this thing about the nuclear taboo has been around a while, and I think people take it seriously. So by crossing that, wouldn't you precipitate a broader use, even in that remote use, David, that you referred to, you know, in the against a military fleet in the high seas or a remote troop of military targets?
Well, it seems to me that there is very broadly, widely shared consensus on the legal standards. And as John mentioned, the US military is committed to the proposition that all military operations will comply with the law of armed conflict and all the rest of the international applicable international law, not just nuclear weapons, chemical weapons, everything the US military does will comply with applicable international and domestic law. And you're just right that there is a procedure requiring a legal review before any new weapon can be approved for purchase and for entry into the arsenal. And that legal review applies exactly the kinds of standards that we've been talking about. The categories of legal analysis are, I think, not in dispute. The difficulty, I think, is how you apply those agreed criteria to close cases. And proportionality provides probably the best example of that. In a nutshell, that says you can't do too much damage to civilians and civilian objects when you're pursuing an attack against military objectives. But how much is too much? And depending on what you believe is at stake and what you believe that our weapons would do, there's a wide margin of what might be considered to be too much. The legal analysis done by not just the United States, but I think all the other countries that possess nuclear weapons adopt the point of view that the harm that would be inflicted by our use of nuclear weapons is not too much. It's enormous, it's extensive, it's long lasting, but it's not categorically disproportionate to the value that would be the military gain that would be accomplished by their use. And as an abstract matter, I think you can't get behind that. You just have to do it on a case-by-case basis where, in good faith, I think it's harder to argue that the analysis can be sustained.
Kathleen, did you have comments?
Yes, sure. No, I would have a lot to say here, but I'll try to be brief. First of all, I should say, as I alluded to in my presentation, I think certainly if a nuclear weapon is used very far away from populated areas, let's say against an object, so we set aside the prohibition to cause excessive suffering to combatants, so human combatants are not in the picture, etc. I think there we could imagine, yes, scenarios, using a low yield nuclear weapon, etc. Scenarios where the eventual harm to civilian areas could be deemed to be proportionate, not excessive to the military advantage anticipated. But we must not forget that even in that scenario, the natural environment is a civilian object. So you also need to look at, what will be the impact on the natural environment and how much damage will be caused to the natural environment, for how long, etc. And this needs to be factored in as well in the proportionality calculation. In that scenario of a low yield nuclear weapon in a desert, etc. And also looking at, well, will radiation be spread through winds and other means to civilian areas? But the reality is, I like what David said at the beginning of his remarks, which is, these scenarios are extremely interesting from a law school perspective. We look at the different hypotheses to test the law, etc. But we have to look at the reality of how nuclear weapons will be used. And the fact is, they will be used in or near cities. Planning is being done to use them against military objectives located within or close to cities. And even if hypothetically nuclear weapon states were planning only to use them outside of populated areas, the reality is use of a low yield nuclear weapon in a desert will eventually lead to a reprisal and counterstrike, etc., and therefore escalation, which, by the way, is something that the ICJ itself noted. The ICJ raised the question whether, and stated clearly that there was this major risk of escalation of use of nuclear weapons, such that their use would eventually move into cities, even in the hypothetical scenario that the use would begin outside of populated areas. But coming back to the prohibition of of disproportionate attacks, again, I'll just repeat what I said earlier. It is extremely difficult to imagine a concrete and direct military advantage that would be so important as to justify the colossal civilian harm that would be caused if a nuclear weapon is used in or near populated areas. So if we're looking only at that scenario, use in or near populated areas, it's extremely difficult to find what would be that concrete and direct military advantage, which, by the way, those terms, concrete and direct, refer to a tactical advantage. It is not, as I said, the objective of winning the war, defending the nation, a political aim. It is rather what in that particular attack, that particular military operation, will be the advantage gained by the attacking force by launching this strike. And there I think nuclear weapon states themselves have not shown any concrete scenarios where this would indeed, proportionality could indeed be respected.
Well, Kathleen, if I may be permitted to say something as if I was a panelist, I think that your stronger argument is that even if an attack in or near a city is arguably proportional, it would still violate the prohibition on indiscriminate attacks. The problem with proportionality.
I couldn't agree with you more.
Yeah, the problem with proportionality analysis is that it involves balancing. So I have another question, which is, if you have a certain sort of view of the United States and the world, and Les Aspin did this, 3 decades ago, essentially, is that, U.S. would be better off if there weren't nuclear weapons. There are no other or few other sort of major strategic systems capable of threatening the United States. And obviously, the United States has a very strong military. But, the US is not the only player in the world. There are other countries who may think under current circumstances, nuclear weapons are really important to their defense, and to anything sort of ambitious they may want to do in the world. And so that, that leads in my mind to the following tough question for the United States. If the United States wants to limit or even essentially end its reliance on nuclear weapons, what does it do about the fact that other countries, I'm thinking in particular of Russia, seem almost to have doubled down on their reliance on nuclear weapons? That's the question.
John, I think I'd say, that's one of the strange ironies of the history of nuclear weapons. During the Cold War, after the end of the Second World War, the U.S. made a decision to demobilize, not keep up its conventional military capability, and just rely on nuclear weapons. And it let itself become inferior to the Soviet Union, to the point where, as I understand it, there was a sense that if you had a Soviet incursion into Western Europe, it would be of a conventional nature, that would be a serious problem. And so the US focus was on nuclear. Now, of course, you have the irony that the US, after the demise of the Soviet Union as a nation, built up its conventional weapons so much that now, there is the argument that for a lot of purposes, the US could do without these weapons and is far more threatened by them than a potential use. But I think your point is a reality that while we don't need nuclear weapons anymore, arguably, in that conventional weapons could do, most at least military objectives for us, other countries do, because they're far weaker. And so that just points to the challenge. Governor Brown was talking about the challenge, but this part of the challenge is even huger than he referred to at the time, because you can't probably control the nuclear weapons situation without getting some control over the conventional challenges that other countries have, that they need defense against us because we're so superior with conventional. So I just put that out there. Aren't these two, isn't conventional disarmament and nuclear disarmament so interrelated that we're not ever going to really achieve much on the nuclear without somehow achieving something on the conventional?
Well, that's certainly where I come down. And John, I'm exactly on your premise that if magically nuclear weapons disappeared around the world overnight, the biggest winner in that is the United States, because we have such a massive superiority in conventional weapons, and because nuclear weapons are the only system that really threatens the national existence of the United States. We have the most to lose by the continuation of nuclear weapons and the most to gain by their abolition. And other countries realize that too. For me, that becomes a reason why the TPNW, for all its other possible benefits, is too simple. That it's unrealistic to expect that the world will get rid of nuclear weapons without dealing at the same time with defense systems and with conventional weapons and with with regional disputes and with verification and enforcement. And I think you need to package all of that into a longer term package that would include conventional forces as well as nuclear.
And Kathleen, did you want to comment?
John, I think, you know, from the International Committee of the Red Cross's perspective, I mean, these are questions of strategy and of politics of how to link up these different streams of disarmament. I mean, we're looking at it strictly from an IHL perspective. And there again, you know, the fact that under the law of armed conflict, these nuclear weapons pose very serious concerns and are arguably unlawful in most of the scenarios in which they would be used, must in and of itself drive disarmament efforts. And I would just also note that, you know, my understanding and my reading of the ICJ's advisory opinion is that it found that, and you know, again, I'm not disputing the realpolitik of disarmament, which both Charlie and David have just mentioned, discussed. But, you know, from a legal standpoint, the International Court of Justice found that there is an obligation to take effective measures towards nuclear disarmament, not general and complete disarmament, but nuclear disarmament. And what's more, it found that this is not just an obligation of means, it's an obligation of result, and that this is an obligation of customary law. So, you know, we have, because these are legal commitments that have been made by states. So yes, perhaps one could say this is the ideal of the law versus, you know, certain political realities in the world. But I think, you know, let's look at chemical disarmament, look at biological weapons disarmament, etc. You know, there were times in history where all of weapons of mass destruction were lumped together. And yet, you know, in terms of states saying, well, we need to deal with everything together. In certain regions of the world, in the Middle East notably, this is how it's also being approached. Let's deal with all WMD together. But the reality is today, chemical weapons are comprehensively and universally prohibited. They certainly are prohibited from a customary law standpoint. And the Chemical Weapons Convention is one of the most widely ratified instruments. So what I mean by that is that it is possible to silo, and this is a question of political will, to silo nuclear weapons and get the job done just for nuclear weapons and then move on to other forms of disarmament. I do think it's possible, and it's a question of, yes, I realize there are political challenges today to doing this, but, you know, times change, and this is what diplomacy is all about, and goodwill, and toning down rhetoric and reaching out. And this is where I believe the US can play a very strong role there as well. It's about each nuclear state, weapon state, looking at their own responsibilities and taking the dare I say it, the moral high ground, and having the courage to take the first step and reach out.
So Kathleen, I hope it's okay with you if I consider those your closing comments. David and Charlie, would you like to make closing comments?
David?
Well, so the closing comment I'll make would be the invitation to open up another kind of discussion, which is, so far we've been talking about the use or threat of use of nuclear weapons. An associated important problem would be the legality of the possession of nuclear weapons. The advisory opinion was not directed to that, but that too would be something that we could pursue in depth. The general rule is that it is illegal, as the ICJ stated, it's illegal to threaten to do an act that would be illegal to carry out. And therefore, presumptively, possession of nuclear weapons would be challenged. But it seems to me that that's something that would deserve at least another hour's worth of panel. And I'd be delighted to have you chair that one too, John.
Okay, thank you, David. Charlie.
The final comment I was going to make is sort of picks up off of David's point. One of the things that the ICJ advisory decision in 1996 said that we haven't focused on is what David just alluded to. The ICJ told us that it's unlawful for a state to threaten to use weapons that it would be unlawful for them to use. And we saw today what the makeup of different nuclear arsenals are. We saw that the US nuclear arsenal is very predominantly the high yield nuclear weapons. We saw there's not much at all to this point that in extreme circumstances of self-defense, all bets are off. I mean, I don't think anybody, and Kathleen addressed that perfectly. I don't think any serious international lawyer is really, although the language of the court was not very clear, really thinks that, and other parts of the decision said this, that the exercise of self-defense is subject to IHL. But what we do have is an arsenal which is primarily made up of the high yield nuclear weapons, where the first strand of the ICJ decision kicks in, which is that, well, maybe low yield ones might be, we don't know, because we don't have enough evidence. But if you look at the high yield nuclear weapons, our policy of deterrence, I mean, contrary to what we heard earlier today, to the best of my understanding, I heard it said that, well, Russia's view of deterrence is they'll use it for anything bad that they don't like in the world. But there's plenty of pronouncements out of our government that are much broader than we heard today, and that, to the best of my understanding, say that we reserve the right to use nuclear weapons in any situation where our vital interests are affected. And that threat includes the threat of using the high yield nuclear weapons. So I think there's a serious question that needs to be looked at of the lawfulness of the policy of deterrence insofar as we're threatening the use of the higher yield nuclear weapons. I think it's almost a separate question, but we'll have to have a second day because we're scratching the surface on some of these issues.
All right, well, thank you all for being on this panel, and now we should go onward.
Okay, well, this is a very fast transition. We've had hundreds of people in and out today, and we still have 130 some with us. So, kudos to everyone who is persevering. This panel, as we've conceptualized it, is the so what panel, so we've gone through the day. We've understood that there are UN instruments, and there's treaties and conventions, and there's law of armed conflict. There's this huge body of rules, and has been pointed out, some of them legal, some of them, as Jonathan had said, more political commitments, but there's a huge body out there of restraints and recognized limitations on potential use of nuclear weapons. But the question is, how do we operationalize this? How do we get enforcement of the law and, if possible, the policies that exist? So this last panel, we're going to go on for almost 2 hours. It's a very long panel, and then we'll have some closing comments. But this panel says, okay, how can we do this? And I'm going to introduce our wonderful group of speakers. The way we've divided this up is we've identified a bunch of topics, and you can see it in the agenda for today. The first category is built around litigation, the potential for civil litigation, defense of protesters, maybe shareholder litigation, shareholder resolutions, FOIA requests, and the like. A whole range of potential legal steps that might be taken civilly and criminally. There's areas of civic advocacy, but there's a potential for universal jurisdiction, which really comes under the litigation legal side of things. Political action, election of legislators and prosecutors where that's done, that are interested in enforcing this law. Civic engagement, and very, very importantly, and it has been important during the Cold War, the engagement of major faith groups. And so we're going to hit these topics, And each speakers are going to take the lead on topics, but then we'll have a discussion on each of them. And I think I'm just going to introduce very quickly, and I invite everybody to look at the detailed bios that are in the materials. But I'm going to introduce quickly the speakers, and then we'll start with the legal side, and we'll go through the civic and the political engagement and the like. The first speaker is Laurie Ashton, who is a litigator. She's an attorney, and Laurie has been very active in the international law space, including representing the Marshall Islands in cases we've heard some about today involving NPT compliance. And Laurie will tell us more about that and numerous other areas of engagement through law. And there's a lot to do there. We're going to try to be very practical and assess how we get around the various barriers to justiciability. Next is Jackie Cabasso, who has been a leader in the protest movement for good causes for a long time. It's an extraordinarily admirable career and a sort of an institutional memory of what's been done, what's possible. And Jackie has some, insights that I think we'll all find very useful in terms of how action can be taken, hopefully going forward, to do the kind of thing that Governor Brown was talking about, to begin to change consciousness and the like. Reverend Drew Christensen, a Jesuit from Georgetown, is a leading spokesperson within the Catholic Church on the area of nuclear weapons and control and morality and law and how to deal with the problem. And we'll hear about this. Father Christensen has a PowerPoint, and there's been extraordinary action by the Roman Curia and the Catholic Church during the Cold War and since then, making pronouncements about nuclear weapons. And so there's a real potential to try to influence people that way. Tom Kalina is most recently known, and he's very well known in this field to everybody engaged in it. His recent book with William Perry, The Button, is one we've all either read or are in the process of reading or getting a hold of. The Button, the new nuclear arms race and presidential power from Truman to Trump. Tom is the director of policy at the Plowshares Fund and has been a thinker and writer and speaker on these topics for a long time. And will talk with us about potential approaches with the Biden administration. What can we do going forward? What can we hope for? How can we optimize the prospect? Governor Brown talked about this, of getting that administration fully engaged on these issues. Audrey Kitagawa is going to be an extraordinary speaker this afternoon. She's the chair of the board of the trustees of the Parliament of the World's Religions and too many other positions, including at the UN and internationally. Please look at Audrey Kitagawa's bio. It's absolutely extraordinary. And for the kind of new thinking that Governor Brown was talking about, how can we change our mindset? I think Audrey is one of the real voices that we're going to learn from and help a lot of us who are, it's hard to break out of our patterns of thinking at times, but that seems to be the challenge. So I think, Laura, you're going to lead off and talk about the legal side. I think you're muted, which is what we've all done when we start.
Okay, here we go. Thank you for that introduction, and thank you for asking me to be part of this event. Given the timing, I'm going to try to do a top-line analysis of the litigation issues. I've been invited to speak not as a weapons expert or a policy expert, but as a litigator who has brought cases against weapons manufacturers, against other nations, in the International Court of Justice and domestically. I noticed we've got 3 or 4, maybe even 5 members of the team that represented the Marshall Islands at the International Court of Justice online today. So hello to all those folks. they'll see what a summary version I'm going to give of what we went through. And I'd first like to say that in the field of the sticks and the carrots for trying to get humanity toward nuclear disarmament, litigation obviously falls on the sticks side. It has its advocates, it has its detractors. There are certainly folks who think that you should not bring cases unless you can win them. I'm not in that category. I think that every good case deserves to be brought. I think that whether you turn out to be Plessy versus Ferguson or Korematsu, both of which were decided horribly, or whether you get to be Brown versus Board of Education, just depends on your determination. So I think if there is a good case that meets Rule 11 and the legal standard, corresponding standard at the International Court of Justice, that it ought to be brought, and that folks ought to be fearless and thinking way outside the box on what cases can be brought. Obviously, if we are all rowing in the same direction and the nuclear weapon states are all behaving in compliance with the 96 advisory opinion, then we don't need sticks, we don't need litigation, we don't need fines, we don't need injunctions, we don't need penalties, we don't need to stigmatize them. And if appeals to the moral dimension and reducing spending and national security were enough, we would not be where we are. Those are all very important, and we're going to hear more about those, but they are not currently getting us where we need to be. And if you were on this seminar earlier, you were able to hear from Dr. Ford, which was fascinating, who told us with a straight face that there is not even a scintilla of a hint of a customary international law obligation to disarm nuclear weapons. Needless to say, I don't think that's right under the 96 opinion, and it just shows that that there is a place for litigation, and that we do need to find a way to bring folks like Dr. Ford and others who believe that the way that he does to the table to negotiate. And speaking of bringing folks to the table, one benefit I will say right off the top that litigation has, that some of the other fabulous work that everyone does not offer, is that when you sue someone, they have to answer. It's a very basic thing, but we can write and we can put out fantastic reasoning, and we can put out fantastic articles and books, and I try to read them all. But the United States of America, the current administration, does not have to read them, and they don't have to answer. But when you sue a defendant, a weapons manufacturer, the United States, the United Kingdom, etc., they do have to answer. So that's an upside right there. So I'm going to go very quickly through 4 categories. I'm going to tell you first what we did at the International Court of Justice for the Marshall Islands. I'm going to tell you what we did in the domestic United States court on behalf of the Marshall Islands. I'm going to tell you what things I think we can still do going forward today and going forward at the ICJ. And I'm going to tell you things I think we can still do domestically in the United States, which I think is relevant to this seminar, given what Hans Christensen reminded us all of, and that is that the gorilla in the 9 nuclear weapon states is clearly, ours. So litigating against weapons manufacturers in the United States has a place, in my opinion. So very briefly, those 4 things. At the International Court of Justice, I was one of the first lawyers to put a team together to represent the Marshall Islands, and I'd like to give a nod to David Krieger here, who was a longtime friend of the foreign minister of the Marshall Islands, Tony DeBroom, and the organization he founded, which is the Nuclear Age Peace Foundation. We sued the United Kingdom for breach of the NPT, arguing that they were failing in their obligation under Article 6, as well as their obligation under customary international law, as set forth in the 96 advisory opinion. And just a side note here that hasn't been mentioned so far, while the 96 advisory opinion is great in many respects and challenging in many respects, it remains advisory, which is to say that the United States and the other nuclear weapon states can say correctly that it is not binding on them as an advisory opinion. So that is what you hear, unfortunately. And of course, the parties to the charter, all of them solemnly promise to enforce decisions of the ICJ that they're a party to, but they don't solemnly promise to follow advisory opinions that are advisory only. So that's a gap that we all have to be aware of. So at the ICJ, the Marshall Islands also sued India and Pakistan for breach of their customary international legal obligation to negotiate nuclear disarmament in good faith. Now, we brought cases against the other nuclear weapon states, but because they do not consent to the jurisdiction of the court, they were not obligated to answer. They are allowed to answer, and they can consent, and they could have showed up and answered, but they were not required to, and we knew that going in. So the 3 states required to answer were the United Kingdom, India, and Pakistan. Now, again, this is just a summary. The respondent nuclear weapon states raised many arguments. They raised arguments regarding whether there was even any dispute, whether the Marshall Islands had standing to bring the claims, whether they were time barred, whether there were necessary absent third parties, whether the obligation under Article 6 was erga omnes parties, many objections, and these are all available online in the briefing at the ICJ website, which is one of the best websites around, as an aside. The Marshall Islands case against the UK was lost 8-8. And of course, I would emphasize that there were therefore 8 justices that thought the case should go forward. The P5 were 5 of the other 8 who did not think they should go forward, which highlights the issue of whether the P5 should all have standing seats on the ICJ. And I would note that since that decision in 2016, the UK has actually lost its seat on the ICJ. So there are just 4 of the P5 on that court now. Ties, which is an 8-8 like we had at the ICJ, are broken by the president of the court, which was Ronnie Abraham from France. The current president is from Somalia, and he was one of the 8 in our favor. Several of the justices wrote opinions objecting to the resolution of the case, and in those opinions alluded to the fact that the case could be rebrought by another plaintiff, and that the objections that the nuclear states had could be cured. And so that's a matter of public knowledge now, that those cases could be rebrought and the objections could be cured. The UK has since changed its consent to jurisdiction, so there's an extremely high hurdle against rebringing the case against the UK, but the other cases could be rebrought, and that's something I think should be explored. The decision against India and Pakistan was 7-9. So 7 justices thought those cases should go forward. And again, the P5 were in the group of 9 that did not think so. The reasoning was because they did not think the Marshall Islands actually had a dispute with the nuclear weapon states, which is, there's no other way to say this, that is ridiculous. But that is what they ruled. So I'm going to slip over now really quickly to the case that we brought in the domestic courts of the United States. It was a similar case. It was the Marshall Islands versus the United States for breach of Article 6 of the NPT. That case took 3.5 years. The similar objections were made. The court found, the lower court found that whether the treaty was self-executing was irrelevant because it was between treaty parties. So they agreed with the Marshall Islands on that, but found that the issue was a political question. The Ninth Circuit took a slightly different tact. They misconstrued the word undertakes, which I think we need to have a further conversation about, which is in many of the treaties, including the most recent treaty and in Article 6. They find that word hortatory, which is to say aspirational, even though the international law is clear that when you use the word undertake in a treaty, it means solemnly promise. But the United States courts thinks that it means you're aspiring to do something in the future. I think that it's well documented that the Marshall Islands had a change of leadership during this litigation. And that's one of the challenges that folks have in representing microstates, is that the leadership changes over frequently, and that can affect the direction of the litigation. The Ninth Circuit decision was not appealed to the en banc, and so it ended there. Is there an opportunity for another case to be brought like that? Sure. But the challenge is you need countries that are willing to stand up to the military industrial complex. And it's very hard to find folks that are brave enough to do that, because because of what was said earlier about the financial stranglehold that the that the United States has on so many of these microstates. So very quickly, Charlie, tell me if I'm running out of time, but very quickly, what can we do in international courts? What can be done at the ICJ? I'll just run through some quick things. I don't think we'll be able to get into these in depth, but some quick things that can be done. Number one, this issue of whether the P5 should have ongoing permanent representation on the court. That was eroded somewhat with the UK, but we still have 4 of the P5 holding their seats from the beginning until now. Number 2, more scholarship around the word undertakes, because it is so fundamentally misunderstood amongst the state parties. Maybe that could be something in a future review conference. Number 3, not to take up the defense industry's language on whether the arms race has ended, and rather to speak to the fact that horizontal proliferation is in fact arms racing. Number 4, obviously, working with the new treaty to ban nuclear weapons and moving that forward to the status of customary international law. That's going to take time. The United States is not going to join that treaty, but there are examples of other treaties that have become the law in the United States without the United States joining them. For example, the Vienna Convention on the Law on Treaties is the law in this country, and we are not a party to that treaty. So it can happen. There is much written about whether the weapons in Belgium and the Netherlands are legal under the NPT. No one has brought that case. And again, as I alluded to earlier, the cases under customary international law could be brought. Even the judges that disagreed with the ruling said that they could be brought. And then finally, there's currently a case pending against Myanmar by the Gambia, in which one of the defenses is whether the Genocide Convention includes obligations that are erga omnes partes. And that's the same defense that we saw in the NPT case. Countries can intervene in that case and express their opinion that those obligations are erga omnes partes, which is to say anybody can enforce them. The harm doesn't have to be happening to you in real time. And then quickly, Charlie, to your point of whether cases could be brought in the United States, certainly they can. There have been at least 3 cases in the last year that have been successful in the United States against nuclear weapons manufacturers. In the Oak Ridge, Tennessee case, it was an environmental case relating to the fact that they were modernizing weapons and their environmental impact statement was not current with their modernization, and the plaintiffs won. That issue, I think, applies everywhere where weapons are being modernized. So that is a wide open field with precedent in favor of the plaintiffs. The Hanford litigation was this year, finding a Washington law that presumptively linked nuclear exposure to a long list of diseases, won by the plaintiffs at the Ninth Circuit. So that could be replicated in each state that has workers in the Ninth Circuit, and there is binding precedent. Number 3, shareholder derivative suits. We've talked about this briefly for illegal conduct by the board of directors and the officers. And number 4, there is not precedent on this, but certainly a wide open arena for 10b5 disclosure cases for the top weapons manufacturers and whether they are disclosing sufficiently what kind of weapons they're making and what the effects of them are. So I could go on, At length.
Okay.
but I'm going to stop there.
It's very, there's a lot there. And let me just say, I mean, we still have 130 people. And we hope not only to have future programs, but to enlist people in activities. So anyone who'd like to work on litigations or like to be part of some effort of investigating that or looking at it or discussing it, send us an email and we'll try to get it around to people who can operationalize it. We're now going to hear from Jackie Cabasso, and I think it's fair to say there's really no one in the world who knows more about organizing. And I mean, just our prep session went on and it could have gone on for 5 hours. So give us your, view of the history. And I thought your comments, Jackie, so much on how you see avenues where we can make change going forward. You're still muted.
Sorry about that.
Oh, perfect.
Okay. What I was saying was this is a little bit different than I thought the format we were going to use, but I'll try to do my best to fit in. I guess what I want to say is that, first of all, I'm not a lawyer, but I've worked at the intersection of law and anti-nuclear activism for more than 35 years. So for me, law is integral. And in my experience, what I have learned, I believe, is that litigation and other forms of legal work and legal advocacy are most effective when coupled with a vibrant social movement that can help amplify the messaging, first of all, and open space for lawyers. And we had that kind of a movement in the 1980s and to some extent in the 1990s. I believe we don't have that now. And so our action item, I believe, first of all, is to build the kind of social movement that we are going to need to prevail, which means it cannot be a single issue movement. And I'll come back to that. But let me just give you a little bit of my history as experience. And let me also say that by definition, Western States Legal Foundation, which was founded in 1983 to defend nonviolent anti-nuclear protesters, one of whom was me, which is how I got into this, has always seen itself as kind of at the service of the social movement. And so so the social movement has risen and declined and risen and declined, and that has to a large extent shaped our activities over the years. So, but let me go back to my experience a little bit. As I said, I had no legal experience previous, but my first recognition of the relationship between nuclear weapons and law began on June 21st, 1982, when I was among more than 1,300 people arrested nonviolently blockading the gates to the Livermore Nuclear Weapons Lab in Northern California. Some people on this call may remember that that was the same day that 1 million people filled New York City's Central Park during the United Nations Special Session on Disarmament. We were charged with a traffic infraction for blocking traffic, but spent 3 days jailed in an old military barracks before being arraigned. And as I said, though I had no background in law, I nearly choked on my no contest plea, feeling that I had done nothing wrong and that the criminals were on the other side of the fence developing weapons of mass destruction. So on June 20th, 1983, the following year, I was arrested again at the Livermore Lab, one of 1,066 arrestees who had come to the lab to nonviolently put a stop to business as usual, at least temporarily. This, again, was one of dozens of international days of disarmament actions that took place around the world. And I think the size of the number of arrestees, which of course is like maybe a fifth of the number of participants, gives some ideas to the scale of the social mobilization at that time. This time we were jailed in actual circus tents erected on the local jail grounds because there were too many of us to put in jail. And while we had expected to be charged with the same infraction we'd received the year before, the stakes had been risen and the sentence being offered to those of us who would plead no contest was 2 days in jail and $250 fine plus 2 years probation, which we perceived as a direct attack on the peace movement, as it would place serious limitations on our protest activities. So knowing that we had strength in numbers, we agreed that as many of us as were possible, which turned out to be more than 1,000 of us, would refuse to go to the arraignment until we were offered a sentence we felt was reasonable in relation to the charge. And after 11 days, a much reduced sentence was offered to those who would plead no contest. But while we're in the tent, some of us had begun to talk about the possibility of pleading not guilty and going to trial, because we also recognized that the courtroom was another realm where we could work for peace and disarmament. Western States Legal Foundation, which was newly established and which was part of the legal collective providing support to the protesters, agreed to represent those of us who wanted to participate in a mass trial. And I didn't mention, well, maybe I'll get to this. So a novel representative trial was negotiated by our lawyers and the district attorney. 11 representative defendants chosen by the larger group would stand trial, and I was one of the 11. The other 224 defendants agreed to be bound by the verdict, even though they had been blocking gates and roadways miles apart, in some cases using different creative nonviolent tactics. Not wanting to get sidetracked by the legal technicalities, we had agreed in pretrial negotiations to stipulate that the defendants had been in the road. The group of representatives, lawyers, and actively participating defendants worked closely together, making all decisions by consensus, and which was our preferred method, and even our jury selection was done by consensus. The equal relationship between lawyers and defendants was an important aspect of the trial. So we were charged with willfully and maliciously obstructing the roads near the Livermore Lab, California misdemeanor. And we had planned for a trial lasting upward of 2 months. And we had prepared to bring into court evidence about the lab's leading role in the development of nuclear weapons, its violations of international law, and the imminent danger we were all facing because of these weapons. And our experts who were ready to testify included a former California Supreme Court justice, a US prosecutor from the Nuremberg trials, prominent scientists and politicians, a Hiroshima survivor, and others. The trial took place in a makeshift courtroom at the county fairgrounds because there wasn't a large enough courtroom in Livermore to house all of the defendants and prospective jurors, and jury selection took 2 weeks. So I just pause here for a moment to say, imagine this happening now. I can't imagine it happening now. But this is what was possible because of the social movement. And I'm talking about the scale and so on. The DA presented his case, half-day testimony by several arresting officers and so on. And when our first expert witness was called to the stand, the DA immediately objected. Our attorneys made their offers of proof. 3 defenses were presented, and the court was dismissed for that day. So this is directly relevant to today's conference. Our international law defense contended not only that nuclear weapons are illegal under numerous international treaties banning genocide, mass poisoning, and targeting civilian populations, but that the Nuremberg Charter, ratified by the US, mandates a right of resistance to international law violations. The defense of necessity, long established in common law, allows a statute to be broken in order to prevent serious and imminent harm. And finally, our attorneys argued that we should be allowed to present evidence to our state of mind, as we were charged with willfully and maliciously obstructing the free movement of persons. We contended that maliciously meant more than just intentionally, a meaning already covered by the word willfully, and that our state of mind was not malicious. The next day, the judge ruled out all 3 defenses. And because of the stipulation that we had sat in the road, we were essentially denied the opportunity to present any of the concerns that had brought us to the courtroom. And we decided that the most powerful statement we could make was to not testify at all. I think it was about 6 months later that we had sentencing, and the defendants made statements for the entire day. And I'll just read you one sample short excerpt from a sentencing statement, again, to show you how relevant this international law piece was to the defendants. This particular defendant said, in 1946, I went to Germany to work for the War Crimes Commission as a stenographer. I followed the trials there. Our government and the governments of other countries of the world were trying German officials and German officers for what they called crimes against humanity. The people gave as their defense that they were obeying orders of their government. But the reply was that if you perform acts that are against international law, you're a criminal. And our government now and other governments in this world are breaking international law. They are creating weapons which would kill many more than the millions of people that were killed in Germany. So it is, I believe, the duty, the patriotic duty of every person to protest against that. I should say that this trial and the sentencing and all of these developments around it got extensive media coverage and involved hundreds of people for the entire process. And for me and the other defendants, the experience of the trial was life transforming. The legal defenses we developed in partnership with our lawyers gave me a powerful new language to express my moral outrage and a deeper understanding of the role of social movements that has stayed with me and grown for all of these years. Shall I go on just briefly, Charlie?
Yes,
Or-
maybe just go on to how you see
Yeah.
what can be done, going forward. How do we get people interested?
Okay, well, I just want to mention two points about the two things that have been talked about, the International Court of Justice opinion. I was there to help with the legal team, and it was very thrilling to me to see the same arguments that my lawyers had made on my behalf at Livermore being made on behalf of these countries in the International Court of Justice. And the same thing with the and I should say that this is actually, I think, also very interesting and relevant regarding what the role that that international law can play. As the Malaysian representative told the ICJ, our recourse to the court now is with the full support of civil society. And so working with the Non-Aligned Movement, a consortium of more than 700 groups around the world, formed the World Court Project. And the World Court Project collected individual declarations of public conscience condemning nuclear weapons as immoral and therefore illegal, inspired by the Martens Clause in the Hague and Geneva Conventions, which provides that in the absence of a specific provision, the legality of a means of warfare is assessed in light of the dictates of the public conscience. And more than 1.5 million of those declarations were presented to the court. And similarly, around the Marshall Islands case, there was the Nuclear Zero campaign, is that the right call, which involved hundreds of organizations around the world and which collected 5 million signatures in support of the Marshall Islands cases. So these are three kinds of examples where law and social movements intersect. So as I said, I think that I would like, when we can maybe come back to it under civic engagement, I'd like to talk about Mayors for Peace and the Back from the Brink campaign. But let me, since you want me to talk about where I think we need to go now, as I said, I think our challenge is to build a movement. And I don't think we can build a single issue movement. I truly believe we cannot build a single issue movement, especially in face of the multiple existential crises that we're facing, as well as the multiple domestic crises that we're facing, which really are a matter of survival for a lot of our population. So there is an emerging movement in the United States that I believe has the vision and potential to bring this kind of coalition together. It's called the Poor People's Campaign, a National Call for Moral Revival, which is picking up the unfinished work of Martin Luther King when he was assassinated during his Poor People's Campaign, in which he identified through triple evils of racism, poverty, and militarism, and to which the Poor People's Campaign has added, or I'll say the whole 5 of things now, weaving together the interlocking injustices of systemic racism, systemic poverty, environmental devastation, militarism, and the war economy, and a distorted moral narrative of Christian nationalism, which they're calling a moral fusion campaign. And nuclear disarmament is in there, specifically in the Poor People's Moral Budget, It calls for cutting US military spending by 1/2, 350 billion, which is way more than any of the progressive US groups in the US are calling for, including by closing 60% of US foreign military bases, ending wars in Iraq, Afghanistan, Syria, Yemen, and elsewhere, and dismantling and eliminating nuclear weapons. This campaign has active state-based organizations in 46 of the 50 the United States. It's being supported by an extraordinary range of constituencies, including labor unions, faith organizations, racial justice, anti-poverty, environmental, and peace groups, and is building political power through its We Must Do More campaign, mobilizing, organizing, registering voters, and educating. And on June 20th, when there was supposed to be a mass mobilization in Washington, D.C. because of the pandemic, it was done virally and attracted 3 million participants. So this movement has a lot of potential. I personally was involved in text banking before the election, and we reached out to 2 million people. So I think as a nuclear, this is the last thing I'll say right now, as a nuclear disarmament movement, it is our responsibility, I think, to share our knowledge of the ever-present and growing dangers of nuclear war with other issue constituencies. And we need to work together to understand the common causes of the multifaceted crises we work with the Poor People's Campaign and others, to build a massive multi-generational, multiracial, international moral fusion movement we will need to overcome systemic state violence and build a peaceful, just, sustainable, and inclusive world. And like I said, I'd like to talk a little bit about Marriage to Peace if I get a chance later on.
Okay, thank you so much, Jackie. And I have to say that your point that the way to effectuate change through civic action here is through groups that are motivated by multiple issues is, with your background, a wonderful insight, because it would not have been obvious to those of us who haven't been spending their lives the way you have, that it has to be that way, because your experience is so, based in reality. So that's wonderful.
Thank you, Charlie.
I mean, it really is. Tom Kalina, are you good to go? I see you're here. Your camera's not on. I think we said you'd come. Oh, there you are. Thank you. I think we said you'd come up next. And Tom is going to talk to us about the Biden administration, what we can expect and how we can, get the most that we can get towards the issues that obviously we all care about.
Well, Charlie, thank you very much. Hi, everybody. Jonathan, thanks for inviting me to be here. It's a pleasure. And I look forward to talking with everyone, and then hopefully having some time for Q&A afterwards, because I love that part of these events as well. As Charlie said, I want to talk a little bit about what we can expect from the Biden-Harris administration. And first, a little context. Joe Biden will be the next president of the United States, regardless of what the current president says or thinks. And that's tremendously good news for a more progressive nuclear policy. But the picture is not perfect, right? We are still going to have a split Congress, most likely, depending on what happens in Georgia. As most people know, there'll be a special election for both Senate seats in Georgia in early January. Democrats have to win both of those seats to take over control of the Senate. And I'm not going to predict, but it would seem unlikely for both of those seats to go Democrat. So I would predict that we will have a split Congress, Republican Senate, Democratic House. And that's going to limit what the Biden administration can do on things that require bipartisan agreement in Congress, particularly things that would require 2/3 majority in the Senate, for example, treaties. So with those limitations, let me just say that there's a lot that a committed president, which I think President Biden will be on nuclear risk reduction measures. There's a lot that a committed president can do by executive authority that doesn't necessarily require congressional approval. And so I think that's where we have the most potential with the Biden-Harris administration. So what priorities might we see Biden-Harris administration pursuing on nuclear policy? Well, the first two I would put in the category of cleaning up the mess from the Trump administration. The Trump administration was handed a fabulously good deal on Iran, the Iran nuclear deal handed to it by the Obama administration, and fumbled it and withdrew, and things are much worse than they were before. So the Biden administration, Biden-Harris administration needs to get back in to the Iran nuclear deal and work with Iran to come back into compliance. The administration, the president-elect has said he would do that. So this is not an issue that we need to convince the new administration to do, but we need to watch and make sure that they do it expeditiously and do it right and make sure that it happens. In the same theme of cleaning up the mess, the Biden administration needs to, within 2 weeks of inauguration, extend the New START treaty, which is another thing that the Trump administration had plenty of time to do and failed to do. And so when Biden comes in, he will have 16 days to extend New START, hopefully without conditions and for the full allowed term of 5 years, which the Russians have said they're willing to do. Of course, this is the last remaining treaty that limits US-Russian nuclear forces. And so it's essential that it get extended. And then to build on that, to go further, because we want to go further. We don't want to stop there. But again, if it's a treaty to go further, then that's going to have problems with the Senate that we expect to see. Now, just those two things, New START and the Iran deal, getting those back on track would be tremendously important. But I hope you, and certainly not I, would be satisfied with just that. We want to go beyond that. We want to move from sort of getting back to neutral to making forward progress. And so to me, what I'm looking at is things that would address the danger that Bill Perry and I wrote about in our new book, The Button, addressing the danger of blundering into nuclear war by mistake. And this is what we see, frankly, as the greatest threat facing the United States today, is that there could be a false alarm caused, for example, by cyber attack, and the president would have just minutes to decide whether the attack is real or false. And if he makes the wrong decision, could launch nuclear war by mistake in response to a false alarm. This is certainly something that President Trump could have done, particularly given the fact that he and all presidents have and have had sole authority to launch nuclear weapons with no checks or balances from anybody else, not in the administration and not in Congress. And so we want to make sure or push the incoming Biden administration to address and reduce the dangers of blundering into nuclear war. So there's three things in particular that we would like to see the new administration do. One would be ending sole authority. In other words, the authority to use nuclear weapons first should be shared with Congress. There should be no sole presidential authority for first use. And we should also prohibit first use in a blanket way. And this is something that there is some hope for. The Biden campaign and Vice President Biden himself at the time spoke in favor of the sole purpose of nuclear weapons. In other words, the sole purpose of nuclear weapons should be to deter their use by others. To me, this is very close to a no first use announcement. And we need to work with the new administration to make sure that a sole purpose policy is equivalent as much as possible to a no first use commitment. And again, that would eliminate the sole authority of the president to use nuclear weapons first, because there would be no first use allowed. And lastly, we need to retire the weapons that are most vulnerable to being used first or being used under pressure of a false alarm. And that is our land-based ballistic missiles, our ICBMs. These weapons are not needed for deterrence. We don't need them in particular because we have our nuclear weapons based as well on submarines at sea and on bombers that can be sent aloft. And so not only are the ICBMs redundant, but they're tremendously dangerous because the Russians know exactly where they are. They're on high alert, and they are the weapons that the president would be under tremendous pressure to use in a alert situation out of fear that if a nuclear attack lands, then those weapons would be destroyed. So there's pressure to use them or lose them before an attack arrives. And that's where you get the danger of responding to a nuclear attack that turns out to be false and starting nuclear war by mistake. This is a particularly important issue too, because the Air Force is in the process of a $260 billion program to rebuild the ICBMs. And now is the time to cancel this program before it becomes too big to fail. So me personally, this is the highest priority thing. And for Plowshares, this is the highest priority target we're going after, is canceling the new ICBM program, because now's the time to do it. If we don't do it now, we'll be stuck with these weapons for the next 50 years. And there's a real, and they play a significant role in the risk of blundering into nuclear war by mistake. Lastly, I want to talk about some of the lessons that we learned in the Obama administration, right? President Obama came in so many years ago with great hopes of eliminating nuclear weapons and reducing nuclear threats. He got some of those things done, but not near all of them, in part because when he came in, the interested public felt that he had this, right? He had it covered. And so they could go off and worry about other things. And that was a problem because there wasn't enough public support in Congress or in the general public to give President Obama the political capital he needed to get these things done. And when he came into office, he realized just how hard it is to take on the nuclear bureaucracy. So we need to not make that mistake again. I mean, look, we've done the most important thing. Job one, elect a president that cares about these issues. Okay, done. We got that. But we have to engage. The public needs to engage with that president to make sure they deliver on the things they need to do. And here I wanted to agree with Jackie that what we need is a multi-issue campaign that brings nuclear policy together with other issues, because, you know, gone are the days we're going to have a single issue campaign on nuclear weapons. It's just not going to happen. But the way I look at it is that, you know, the Biden-Harris administration is coming in with clear priorities: fix the economy, fix COVID-19, take on climate change, address racial injustice. All of those things are tremendously important. They're going to take a boatload of money. At the same time, we can't just print all that money, because the Republicans are now, my prediction, are going to rediscover the problems with deficit spending, which they forgot about for the last 4 years. So we won't be able to just rank up the debt as we have. We'll have to cut programs to pay for new programs. Well, from my perspective, where we have money to save is in the nuclear program. We have the Trump administration is planning to spend upwards of $2 trillion to rebuild the arsenal over the next 30 years. We can save a lot of money from that, in particular, the $260 billion for the new ICBM. So I want to take that $260 billion for the new ICBM and give it to rebuilding the economy, give it to addressing COVID, to addressing racial injustice and climate. So I want to build a coalition, a campaign with other communities that need federal funds, because we've got, in the nuclear space, federal funds to give away. And I think that could be a very powerful movement. In fact, next week, Plowshares Fund is sponsoring an event on Wednesday. One of our panels will have members from those different communities to talk about all the needs in those communities that would be much better use of that money than spending it on nuclear weapons that would make us less safe. So let me end it there, but with an appeal that just because we've elected a President Biden that cares about nuclear policy issues, people cannot walk away from this issue. We need to stay engaged. We need to support the president to get these things done, President Biden, that incoming President Biden. And the way to do that is a multi-issue campaign that ties nuclear policy together with other prominent issues. And Charlie, I will end it there.
Thank you, Tom. So this is very encouraging, but also is putting a lot of work on our plate, because Laurie told us the many things we can do. Jackie told us the many things we can do. And now, Tom, you've done it again. The next two members of the faculty, and I think we've said Audrey will go first and talk about faith groups and communities working together, also about the role of feminism in terms of having, hopefully achieving improvement in how international security affairs go, and ethical and moral issues. And then Father Christensen is going to talk with specificity about what the church has done and what the papacy has done in terms of several work products that have been helpful, and then some cooperation between the Georgetown and Notre Dame and Catholic U that I think is a model that maybe we're going to hopefully be able to develop going forward. And I'm delighted, by the way, to see that Dean Ferrick is still with us from Fordham. So maybe we'll, be able to expand in that regard too. And then I think we'll have time to do the discussion, which we said we're going to do too, and go back on all these things and give everybody a chance to comment on the various comments others have made. But Audrey, please take it away. You're muted, as we all are when we start talking.
So thank you so much, Charles, and good afternoon, everyone. And I really want to thank the many co-sponsors and organizers of this day of programming and for the privilege to be on this panel. And my special thanks to my dear friend, Jonathan Granoff, for the special invitation to be here today. So this panel today is examining the approaches for advancing not only the rule of law regarding nuclear weapons, but also morality regarding nuclear weapons, as well as the specific actions which have been taken to address what communities of faith have and are doing on the nuclear issue. So let us remember that over 84% of the world's population are adherents of some faith tradition. So this represents a huge constituency of people. It is a tremendous resource. Leading guiding institutions, including the United Nations, have increasingly come to realize the importance of engaging with faith communities to advocate for as well as implement important programs and initiatives. And significantly, communities of faith provide very important voice of inspiration that finds its origins in our sacred texts and traditions. The voices of faith communities have been instrumental over eons to provide the voice of inspiration as well as the voice of advocacy. And they have also demonstrated living their values by providing needed on-the-ground services to communities in need with humanitarian outreach and services. So I begin by mentioning the work within the interfaith communities with which I personally have been involved. And I want to start with the Parliament of the World's Religions, which started the global interfaith movement, which we see today is so vibrant. And it started its inaugural convening in Chicago in 1893. And the Parliament has embraced the nuclear weapons issue and addressed it at each of its international convenings. And Jonathan, by the way, who is our special ambassador of the Parliament on the nuclear issue, has been very instrumental in putting front and center the nuclear issue at all of our international convenings, from Cape Town, South Africa, throughout the years that we have convened, he has always been present on the nuclear issue. So in 2018, the Parliament came out with a passionate call for the abolition of nuclear weapons. And since that time, the Parliament has deepened its cooperative engagement by partnering with other faith-based organizations to join in another joint statement with United Religions Initiative, the Charter for Compassion, and Religions for Peace called the Hiroshima-Nagasaki Accord, which we prepared in preparation for the 75th commemorative remembrance of the bombing of Hiroshima and Nagasaki. So now this accord has 9 action items for not only faith communities to start to implement and commit to, but for all people everywhere and across disciplines. So we also created a video to make the moral case for the abolition of nuclear weapons to commemorate the 75th anniversary of the bombings of Hiroshima and Nagasaki. And links to the video as well as to these statements have been provided to the conference organizers. So I hope all of our participants will have access to be able to read as well as view this commemorative video. So 53 faith communities from diverse faiths committed to a nuclear weapons-free world presented a joint statement at the 3rd session of the preparatory committee for the 2020 review conference of the parties to the NPT. So these powerful advocacy tools continue to be developed to address the abolition of nuclear weapons. And faith communities are more and more coming together in cooperative engagement to show their mutual commitment to a nuclear weapons-free world. And United Religions Initiative, which is comprised of more than 800 cooperation circles around the world, has a very well-developed cooperation circle created just for a nuclear weapons-free world. And through its cooperation circle called Voices for a Nuclear Free weapons-free world. And the Parliament joined in its weekly meetings to work on the Hiroshima-Nagasaki video, together with representatives from the other organizations, United Religions Initiative, Charter for Compassion, and Religions for Peace. So what this is showing is this cooperative engagement where communities of faith, faith-based organizations are coming together to create the important mobilizations on issues just as Jackie has indicated is so very important to do. And increasingly, we find that oftentimes traditional churches are losing their, congregants, and the young people are not necessarily attending as their parents and grandparents and elder generations used to have the primacy of attending church and being part of the community provided by the sense of community provided by church organizations, etc. As they find more and more their commitment to activism. So we see an action-oriented model, and the phrase sacred activism has been coined to show that young people are willing to address and to commit their resources of their life force, their energy, and their values, a statement of their values towards these particular issues that they can get very passionate about. So it is an expression of how they are choosing to express their values. So the 9 action items presented in the Hiroshima-Nagasaki Accord indicates, an across the board kind of intersectionality that we have been talking about, multi-issue, and not only multi-issue, but multi-constituents to mobilize around issues. And so it mentions if you are young, demand urgent governmental action before these weapons can rob you and your children of a future. If you're a diplomat, keep pounding away on the fulfillment of legal commitments already contained in treaties in force that call for the reduction and elimination of the threat posed by these weapons. And if you're a religious leader, pray, preach, prophecy to stop the nuclear end of the world. And if you're not informed about the nuclear issue, become educated. Subscribe to a nuclear newsletter and wake up. If you're a politician, join parliamentarians and leaders worldwide who are working to stop the modernization and expansion of the capacity of nuclear weapons in quality and quantity, and advance policies and legislation that reduces the threat of the use of weapons, stop their spread, and lead to their elimination. And if you're a citizen, join a nuclear weapons abolition group, march in the streets, write letters, pray fervently, and demand that institutions stop investing in the nuclear weapon industry. If you're a scientist, don't be used by politicians who champion nuclear stockpiles. Find solidarity in your ranks and reach across national boundaries to scientists in other countries. If you are an environmentalist, recognize that nuclear weapons are the immediate and ultimate climate change for all time. And if you are a nation armed with nuclear weapons, join with other nuclear nations to establish a joint enterprise committed to working for the elimination of nuclear weapons. So this is a call to constituents from all different walks of life to come together and to create the kind of mobilization that Jackie and Tom so passionately addressed. So the public statement to the third session of the preparatory committee for the 2020 review conference of the parties to the treaty on the non-proliferation of nuclear weapons delivered gave the 4 areas of these communities of faith urging action by states. And the indication was the nuclear weapons profoundly violate all values and commitments, that we can never accept a conception of security that privileges the concerns of any state or nation over the good of the human and planetary whole. And the horrific destructiveness of nuclear weapons makes their abolition the only path to authentic human security. And in July of last year, in an important step toward a world free of nuclear weapons, the TPNW was adopted by 122 governments, and they were strongly urged all states that have not done so to sign and ratify it. So people, as people of faith, this group urged the General Assembly to do 4 things to address the issue of disarmament, not only as integral to the security agenda seen from military and political perspectives, but also as a moral and ethical imperative. And 2, to support proposals for substantive discussions in multilateral forums on a legally binding instrument to prohibit LAWS. So 3, heed the voices of the words Hibakusha, all the victims of nuclear weapons, and recommit to the unequivocal undertaking to achieve and maintain a world without nuclear weapons. And 4, to recognize that the fundamental justification for the TPNW is the prevention of the catastrophic humanitarian consequences of any use of such weapons, and that its early entry into force is absolutely necessary. And I want to mention the wonderful panelists that we have this afternoon, Father Drew Christensen, who will be speaking next. And he said clearly that we should cease to imagine nuclear weapons as tools for us to manage, but rather as a curse we must banish. And Beatrice Finn, the executive director of ICANN, said, you know, humans harness the power of science to build these weapons, and we have harnessed the power of faith to stop them. So this aspect of faith, the advocacy and importance of them, and the voice of inspiration which they have provided are fundamental to helping us to not only have faith, but deepen our faith, but to have hope, and the hope that we can create a better future. And the advocacy of influential religious leaders. There are 2 I will mention today. Of course, there are many, but Pope Francis, who leads over 1.2 billion Catholics, and His Holiness the Dalai Lama, who is also Nobel Peace Laureate with over 367 million adherents. And in his speech in Hiroshima, Pope Francis took a definitive stand, and he said the use of atomic energy for purposes of war is immoral, just as the possessing of nuclear weapons is immoral and is to be condemned. So His Holiness the Dalai Lama, who speaks and preaches and teaches nonviolence, said, "We human beings have created many of the problems in today's world. And as long as we have strong negative emotions and we view our fellow human beings in terms of us and them, then there will be a tendency to try to destroy them. And we must recognize the oneness of humanity and understand that we will not achieve peace merely through prayer. We need to take action. And this is why it's so important that this panel that we have constituted today is specifically designed to address action items. And, Jackie spoke about Martin Luther King, and she gave his 3 pillars of, movement. And in his sermon, Loving Your Enemies, he said, "It is an eternal reminder to a generation depending on nuclear and atomic energy, a generation depending on physical violence, that love is the only creative, redemptive, transforming power in the universe." And King wanted all people, all nations to come together to work out their differences through what he called a great fellowship of love. The world can achieve peace and nuclear disarmament. And so I give my great appreciation to all of these inspiring leaders, whether religious or not, who articulate what it is to be authentically human and to find that moral ground within ourselves, which gives rise to all of our religions and yet is transcendent of all religions. And it is that life given by the divine creator of all there is sacred. So thank you so much.
Thank you so much, Audrey. This is so inspirational. I mean, it's hard to talk of it as an action item, although it is. It transcends action to call upon us to just change ourselves and achieve a greater potential of our human nature. So the action list expands. Father Christensen, Drew, would you talk us through the great work you've been doing? And Simona, would you put up Father Christensen's PowerPoint so we can all see it?
There we are.
Here we go.
Thank you, Charles. I want to thank you and Jonathan and Ed Lindsay for inviting me to be with you today. And I want to thank Audrey for reading my work so attentively. In talking about the church, I don't want to talk exclusively about the Catholic Church because many of these activities we've undertaken ecumenically and interreligiously. We've learned from other denominational practices, as I'll point out, and we carry out a lot of this work interreligiously as well. So what I hope is that I'll exhibit various ways in which, various dimensions in which the Catholic Church has been involved, which all religious organizations can be involved. There's one distinct dimension, that's the diplomatic, but by and large, religious organizations are involved in civil society and in the UN structure in very deep ways that they weren't 25 years ago. And so they've been involved in this whole discussion too. So they're also part of the diplomatic world in a broader sense. So the first dimension I want to talk about is that of pastoral care. So next slide, please. So in pastoring, the first mode that we think of reaching the faithful is through preaching. The late Andrew Greeley, a sociologist and priest and a pollster, used to say was the Sunday homily was the place where most Catholics learned about the church. Well, I'm afraid that on War and Peace, they may learn too little, or what they learn may be wrong. The church has changed its position. The position has evolved not only as events have changed and the climate has changed, but also as moral insight has changed. So first we accepted nuclear weapons as part of a necessary evil world. And then in 1963, in 1983, the Pope John Paul II and the US bishops said, no, we can only accept deterrence under strict conditions. And as those conditions were no longer met, they began to say, no, abolition has to be the end of policy. And then finally, under Pope Francis, the church has signed on to abolition under the treaty to prohibit nuclear weapons, but also in his own teaching, condemning both the possession, the use, and the threat to use nuclear weapons, thereby condemning nuclear deterrence as well. And so to preach on this issue, clergy must understand that there's been an evolution of the teaching, and that whole teaching must be taught, and it must be made church-wide and parish deep. Preaching, I think, has a special opportunity in the upcoming religious seasons of Advent and the pre-Advent, where there's a lot of contemplation of the end of time. Nuclear weapons are often looked at from the point of view of the apocalypse. But also in Advent, we're looking at the advent of the kingdom of God, where peace flourishes in a new way. And so there's opportunity to bring up these issues in a special way. Also, there's a teaching function with relation to the sacraments, particularly in preparation for entrance into the church, either through baptism on the part of adults who are non-Christian, or through confirmation if they come from other Christian denominations. And there's a long process called Rite of Christian Initiation for adults, where new Catholics can learn about this teaching, and they ought to learn about it as part of making it church-wide and parish deep. There's also a question of adult education, and this is the area where I think it's most possible to do education. That the clergy sometimes are afraid of talking about difficult issues like nuclear war because they're not prepared, but also because it may divide the congregation. And it's easy, I think, to hand all the adult education to competent lay people who are competent not only in the topic, but in the ability to lead in a serious discussion. And many polls that we've taken have indicated again and again that people believe that congregations are the place where they want to talk about moral issues and expect to talk about it. And so all a clergyman has to do, a clergy person, is to host an event and let the adequate lay leadership take it over. I think there's another dimension to this, which is that these can be communities of moral discourse, as Jim Gustafson, a Protestant theologian, called them, where you simply are talking about the issues. But in modern Catholic teaching, there are also communities of discernment. People come together to look at the current situation of the world and see what God is expecting them and take decisions together about that. And that should be part of what goes on in adult education. And finally, there's pastoral care. And ordinarily we think of that in confession, in confessing sins of participation in evil even, but also a spiritual direction. And the image here I have is our patron saint, founder, St. Ignatius Loyola, with his finger over his mouth indicating, shh, silence, listen to your heart. And he's kind of saying, he's presented here, and this is an unusual image of him as a spiritual director and kind of the founder of the modern tradition of spiritual direction, indicating that what we ought to be doing is helping people through their own discernment. Everyone is called to discern what to do in response to this issue. And the duty of the clergy is to help people through that. And that's pastoral accompaniment. Pope Francis has written glowingly about that kind of process, and I think we ought to adapt it. Next slide, please. This is the domain in which I work principally. You see here three of my colleagues with whom I work, four actually. The man with his back to you is Cardinal-elect Silvano Tomasi, who's just been named a cardinal, and he's been really the leader within the church with Pope Francis on this issue. In front of him is Marianne Cusimano-Love from Catholic University, and Jerry Powers from Notre Dame, and Alessio Precarario from the Vatican Curia. And this is our January conference here at Georgetown on the Pope and the Bomb. Together, we work in a group called the Project for Re-engaging the Catholics on Nuclear Questions. We do a variety of things. One of the things we're aiming at doing is educating the next generation of nuclear arms negotiators and nuclear abolition advocates. And we've had a succession of summer institutes. This year we postponed it, and now we'll have a mini course in January 11th to January 14th online, and we're hoping that we'll get students from Harvard universities and frequently from other colleges and universities as well. We provide internships, and they're broad. We promote internships. One of my own students here at Georgetown was a member of the Vatican delegation to the negotiation of the Treaty on Prohibition of Nuclear Weapons. And I like to say it was the first time that we had a Jew as a part of the Vatican delegation. He really acquitted himself well there, and he's still part of our work. There are international exchanges. Back in the summer, on the anniversaries of the bombings, and then again in early October, we did a series of conversations with the Archbishop of Nagasaki, who himself was Habakosha, having been in womb at the time of the bombing. And we involved students from Japan and Korea, from the US and elsewhere, in conversations with him and with one another on these issues. And the students are now continuing that kind of exercises. I just had one last night. In addition, we run conferences, and in January here at Georgetown, in that conference I mentioned on the Pope and the Bomb, we have presenters from a book that I'm editing on kind of pastoral and moral guidance for people in the nuclear field, and people, especially for people, clergy and pastoral workers who need to advise them, need to accompany them in dealing with the issues that they face now that the Pope has condemned nuclear weapons and deterrence. Some people may really face hard issues, and the idea of this forthcoming book will be to help guide them, and this conference is a foretaste of that. So that's some of the work of teaching and scholarship we do. Finally, the Holy See has a unique position as being a member of many treaties and an observer member of the UN. It chooses to do that, although in the negotiations on the treaty to prohibit, it was permitted to be elected, and was chosen by the other members to be a voting member of that group as well. But the Holy See is the oldest diplomatic entity in the world, and so it continues to exercise a diplomatic function. The Holy See, if you will, is the public face of the Catholic Church in the international community. It's the way it relates to the wider world, and especially to the state system. Under that title, it's a permanent observer at the UN in New York and the UN agencies in Geneva. And it's state party to a number of treaties, including the Non-Proliferation Treaty, the Treaty to Prohibit Nuclear Weapons, and is a member state of the International Atomic Energy Association. Agency, I'm sorry. It's been involved in a number of activities in this area in recent years. Its work in nuclear weapons is part of a continuing program of promotion of the humanitarian considerations in the issues of limitation of weapons, which included work on landmines, cluster munitions, and the arms trade. And as I said, it's been a participant in the humanitarian consequences movement, a series of meetings promoted by civil society and the non-nuclear weapon states, beginning in 2013 and leading up to the end of 2014, that laid out contemporary knowledge about the consequences of nuclear weapons for humanity and for the planet, and for recovery of the planet and recovery of civilization if there were ever a nuclear war, which increased the weight of the knowledge of the need, and therefore the need to abolish nuclear weapons. Pope Francis, as I said, has condemned the possession, the use, the threat to use of nuclear weapons, and therefore deterrence, and most notably in Nagasaki and Hiroshima, but even the year before in a conference at the Vatican. And the book you saw before, A World Free from Nuclear Weapons, that we've published from Georgetown, presents the talks given there, including talks by a number of Nobel laureates and diplomats who were involved in the creation of the treaty. Among the more recent pronouncements of the Holy See in the recent weeks has been Archbishop Gallagher. He's the Vatican foreign minister. His presentation on the day of to the General Assembly on the day for elimination of nuclear weapons, in which he, among other things, said that there are no legacy rights. States have no legacy rights to nuclear weapons. A kind of formula for saying the nuclear weapon state should not treat the NPT as a treaty that guarantees them possession of nuclear rights. Henry Kissinger, when he came to join George Shultz's effort on abolition, argued that the time had come when the US could no longer think of itself as having, being able to have nuclear weapons when no one else could have them, because the world was too threatened by the multiple states that had weapons and the instability of the current multipolar situation. And so he, of all people, ultra-realist, said ultra-realism calls now for nuclear abolition, along with George Bush and George Shultz, rather, and Sam Nunn and Bill Perry. And then most recently, just within the last couple of weeks, Archbishop Kasia, the Vatican ambassador to the UN, at the Fourth Committee. The Fourth Committee is the one that considers issues of nuclear disarmament and international security, delivered a statement on general issues that need to be looked at. But he put a special emphasis on the need to pursue the sixth article of the NPT, the pursuit of general and complete disarmament, that is, disarmament on nuclear weapons to go with conventional disarmament. Charles Moxley earlier said there's an irony in that was once something that Russia wanted, now, but the U.S. doesn't want. The U.S. wanted, rather, and now Russia would want it because of the disparity in conventional forces. The Holy See is now arguing that really this is the time to pursue both sides together, so that we can have a stable movement downward towards a non-nuclear peace. And finally, this document that you see there is the document of ratification of the Treaty to Prevent Nuclear Weapons signed by Pope Francis on the 26th of September in 2017. And if you go to the next slide, please. Well, the next two slides provide resources, and since these presentations will be available online, you can go there and look for these resources. There are 2 pages of resources here, and I hope you'll be able to take advantage of them. Thank you all for listening.
Thank you, Father Drew. It's extraordinary, the range of actions that are taking place now. So there's a lot to build on here. I think one area we talked about in our prep that we didn't get to is Jackie was going to tell us about parliamentarians, and that's a huge movement that we really should talk about. And then I think we should just have a general discussion within the panel of reactions to one another's comments and the like.
Okay.
Jackie, you're
Yeah,
muted.
mayors, not parliamentarians.
Yes.
Okay, first of all, I just wanted to say that I wanted to pick up on and reinforce Tom's note that we really need to push hard on the new Biden administration. I will note that Obama's nuclear posture review did not accept the sole use doctrine. So we really have to do that. So one mechanism for doing that is through mayors. And Mayors for Peace was established in 1982 during the UN second special session on disarmament by the mayors of Hiroshima and Nagasaki to promote the total elimination of nuclear weapons. With active support from civil society, as of November 1st, membership has grown to nearly 8,000 cities in 165 countries with 218 US members. Mayors for Peace seeks to achieve two key objectives: realization of a world without nuclear weapons and realization of safe and resilient cities, which taken together will lead to lasting world peace. And here again is a multi-issue approach. Mayors for Peace has ECOSOC status and works closely with the UN Office of Disarmament Affairs. In the United States, Mayors for Peace works closely with the US Conference of Mayors, which is the official nonpartisan association of more than 1,400 cities with populations over 30,000. The US Conference of Mayors has adopted Mayors for Peace resolutions for 16 consecutive years. In 2019, one is called Calling on All Presidential Candidates to Make Known Their Positions on Nuclear Weapons and to Pledge US Global Leadership in Preventing Nuclear War, Returning to Diplomacy, and Negotiating the Elimination of Nuclear Weapons. This year, the US Conference of Mayors adopted a resolution calling for human-centered security in a time of global pandemic, demonstrating that local elected officials in the world's leading nuclear armed state understand the internet-connected prerogatives for human security. The new resolution calls on the President and Congress to support the UN Secretary General's call for an immediate global ceasefire and international cooperation to address the COVID-19 pandemic, to reconceptualize security in human-centered terms by redirecting funds currently allocated to nuclear weapons and unwarranted military spending to support safe and resilient cities and meet human needs, and to lead global efforts to prevent nuclear war and actively pursue a verifiable agreement among nuclear armed states to eliminate their nuclear arsenals. Now, this last one actually is a restatement of their previous commitment to the Back from the Brink campaign, which is what I wanted to bring to folks' attention, again, as a way of putting pressure on the new Obama administration. The Back from the Brink campaign calls for renouncing the option of using nuclear weapons first, ending the sole unchecked authority of any US president to launch a nuclear attack, take US nuclear weapons off hair trigger alert, cancel the plan to replace the entire US nuclear arsenal with enhanced weapons, pursue a verifiable agreement among nuclear armed states to eliminate their nuclear arsenals. And this has been endorsed by 352 organizations and 47 municipalities, including Washington, DC, Baltimore, Salt Lake City, Honolulu, and Los Angeles, as well as the state legislatures of California, Maine, New Jersey, and Oregon. So that is a live and active campaign now that Mayors for Peace is part of in the United States. So that's what I wanted to share with you about
Okay,
that.
terrific. Before we go back to the panel, when I refer to parliamentarians, that is a program that GSI, Global Security Institute, has. And I think Jonathan's going to tell us briefly about that.
Right. Well, the Parliamentarians for Nuclear Non-Proliferation and Disarmament is in over 80 countries. There's over 800 parliamentarians in it from multiple parties. Jeremy Corbyn was a co-president. Ed Markey is a co-president. Foreign leaders would include Helen Clark, the former Prime Minister of New Zealand. Laura Chinchilla was the president of Costa Rica. So it's very high level, and it's really put together by an amazing, energetic visionary, Alan Ware. And its goal is to educate massive numbers of parliamentarians on the imperative of nuclear disarmament and to share policies and proposals that they can take and do within their parliaments. And I commend their website is pnnd.org, Parliamentarians for Nuclear Nonproliferation and Disarmament. And it's a real, it has not reached anywhere close to its potential for simple lack of funding and organizational support. But it has tremendous potential to bring together the movements dealing with climate, human rights, and disarmament, because we discovered that the same parliamentarians who care about nuclear weapons are exactly the same parliamentarians who are on the front lines on climate change. So this is it is a robust organization with even greater potential.
Thank you, Jonathan. Let me ask Tom Kalina. Tom, there's been a question raised in connection with your comments about things the Biden administration is likely to do and might be persuaded to do with respect to the scope of the expenditures and so forth. To what extent can the administration just say, I'm not going to spend them?
Well, one of the first things that an incoming Biden administration will have to do is take the draft budget for the next fiscal year from the outgoing Trump administration, mark it up because there won't be time to do a top to bottom new budget, and send it to Congress as the Biden administration's first proposed budget to Congress. In that budget, for example, the Biden administration could zero out funding for the new land-based ballistic missile, the new ICBM, just zero it out. So the new administration will have a tremendous amount of latitude. Now, of course, Congress can try to put that money back in, but then you'll have, presumably a split between House and Senate, and then the White House will get to decide. So I kind of like those odds. But yeah, a new administration will have a lot of influence over its own budget to begin with. And then because of the power of the veto, can have a lot of influence with how the congressional budget process goes. But it all starts with the budget submission that the new administration will put together in the spring.
You seem somewhat optimistic on the reining in the expenditures, but there's so much money going to such a diffuse group of companies and efforts. How feasible is it that we're really going to rein that in materially?
Look, I'm hopeful, but I'm not confident. I completely agree that we are up against it with, the hundreds of billions of dollars that is going to defense contractors and the influence that buys you in Congress and other places. So we are outgunned on many levels. What gives me hope is that, again, the new administration is coming in with so many needs on the budget front, so many higher priority needs to fill than new nuclear weapons. And that if they're reasonable folk, which I think they are, and they're looking for places to save money, then the defense budget, and within that, the nuclear weapons budget, is just an obvious, reasonable place to go.
Let me ask kind of an action-oriented question. As I said, we've had hundreds of people. We now have 105 people here. And let me remind everybody, we're going to have a virtual reception after this panel and some concluding comments and so forth. So we do hope people will stick around. But where's our action item? For instance, I'll ask, and John Burroughs, I don't see you right now, and Ariana, Jonathan Granoff, I'll ask you, Ed Lindsay, people who are on this program, the 105 now who are here, who can they reach out to be part of the kind of effort? We've defined action items, but now, we have to operationalize it. So who's going to coordinate this? What organization or person can be the person? And this was not a scripted question, but this discussion has been so hopeful. It cries out for, somebody, for some coalition of people, you know, who can coordinate the interest that this program has obviously discovered, really.
Well, Charlie, this is John Burroughs. I'm going to take that as a question that I must answer. And certainly, if you're interested in working as a lawyer or in legal related advocacy, get in touch with Lawyers Committee on Nuclear Policy, contact at lcnp.org. But I don't think we can volunteer to be a center for activism in general.
Jonathan?
Charlie?
Yes, please.
Well, if you're a lawyer, join the International Law section of the ABA, one of the sponsoring organizations, and join the Task Force on Nuclear Nonproliferation, which I chair. And there's a Committee on National Security where I'm a senior advisor. And these committees, we already have 2 existing American Bar Association resolutions that are relevant. One is for ratification of the Test Ban Treaty, and the other is for the fulfillment of the promises in the Nuclear Nonproliferation Treaty. So there's ample room to push the American Bar Association formally to lobby resolutions which took years of hard work to obtain. And that is a strong, powerful, very effective lobbying arm that has the potential to actually make a bipartisan difference, because the ABA proper has over 400,000 lawyers. And the only thing that's lacking is a little energy to put it together. The other thing I would suggest is that it would be extremely valuable if a organization in Washington gathered together a group of thought leaders in the different movements to meet together on a regular basis through Zoom to develop the coherence in strategies. First, beginning with the arms control disarmament community, but then having as part of its agenda how to build bridges with the natural allies that we have in the human rights and climate movement. And I end by saying our adversaries have created unnatural alliances. If you're against abortion, statistically in the United States, you're likely to be for more prisons, you're likely to support space weaponization and more nuclear weapons. There's no relationship. This is an artificial alliance that's been created. But we have natural alliances that of interest and sensibility, but we haven't developed a narrative or a set of principles that would allow us to coordinate our efforts. Thus far, the climate movement, the environmental movement, the human rights movement, the disarmament movement have been siloed in their funding and in their metrics of success. I think that it's time that we brought these movements together, and so we need some organization to convene thought leaders to come up with a strategy. And it should also include, because these issues are global in nature, a global dimension, not just the Washington Beltway mentality, but these issues are, especially people in the climate, they care about the global perspective. And we have to bring together those of us who work in the UN environment with those who work on the Hill.
That is terrific. What about, Jackie, the Western States Legal Foundation? Do you all need people to reach out to you? I mean, I know your organization does a lot of work across different areas.
Mm-hmm.
So is there an appetite?
I would be happy to hear from anybody who is interested in following up on anything I said, but I wanted to respond to what Jonathan's saying and say, we must be very, very careful. There are a lot of formations out there now, a lot, that are not necessarily in touch with each other, some of which have very similar agendas, some of which are not. And so a little red flag goes up for me when it's, say, a DC group should be doing the convening, because there are a number of coalitions, or that are national around the country that are dealing with racial justice, with economic justice, with environmental justice, and so on. So I'm just saying it needs to be done thoughtfully if that's an approach. But there are another approach is to try to get people's interest and feed them into existing organizations and formations to try to strengthen existing organizations. There's one coalition on nuclear that comes to my mind, which is it was formed for the Hiroshima Nagasaki 75th anniversary, called Still Here. And that brought together an unusually broad range of nuclear, the spectrum of nuclear arms control and disarmament groups, and a little bit broader than that. And there is now a listserv, and that group is going to start meeting regularly to see how we can take the cooperation and collaboration that went into that effort and move it forward. So, and especially some of the legal folks might want to plug into that.
That sounds interesting. Let me ask Ed Lindsay. Ed, I see you're here. You're not on camera right now. But Jonathan talked about opportunities within the ABA to get involved. And I guess my question is whether you think the international section of the State Bar, which you're the chair-elect of, you think there's an appetite there to have action if there's people who are members of the State Bar who might want to join, who might want to act through the State Bar?
I would have to ask people ask the executive committee if there is an interest in it. I am not trying to discourage it by saying that. I'm just saying that I don't want to run off at the mouth and be seen as taking a position I wasn't authorized to take. But I would encourage attorneys with an interest in this area to join the New York State Bar Association International section. And if you really have an interest in pursuing this area, propose a committee, because we have committees on a host of subjects. And if we form a committee and members get active, who knows where it could go.
I have to second Ed's comment because I've been very active in the State Bar for years. My day job is as an arbitrator and a mediator, and I've been very active, and I'm a former head of the dispute resolution section of the State Bar, which is a big section, same in size, I think, as the international. And there, the basic rule is, if you want to see something happen, the way to do it is just to do it. Try to find a couple people, and now you're a committee within the section. So my experience is that the roadway is open for people who want to get involved. And I know many of the speakers throughout the day here, and they've all been active in this field for years. Father Christensen, one question I had is, I mean, the Catholic Church is huge. We heard $1.2 billion. We also heard about your organization, and that you have a cooperative setup. I think if I heard it right, with Notre Dame and with Catholic U as well as Georgetown. Is that something replicatable? Maybe we'll put Dean Ferrick on the spot and see if there's a potential here for maybe Fordham at the university level or the law school level getting involved. You're muted, Father Drew.
It's also expandable. That is, our group would be happy to have other Catholic colleges. The Boston College was once involved, and they're kind of involved on an ad hoc basis. And then we had Loyola along with Northwestern when we did the conversations with Archbishop Takami a couple of weeks ago. So I'd say, yeah, it is replicable and expandable. And the other thing I'd add is that, in a lot of the teaching documents from the Synod, from Pope Francis, they talk about the parish being a place that is a community of communities and of movements. And so that says, it doesn't have to be a formal parish work, but the parish can be a place where there can be a group of moral conversation that will eventually become a group of moral discernment together and social action. So it's possible to put your own group together in a parish context, or to become, part of a wing of Pax Christi, perhaps, or one of the other Catholic agencies to deal with these issues. So as with the bar, I think, people, especially professional people and educators, ought to be in a position to self-organize to start to promote this. The Pope will continue to speak on this. I imagine before Christmas, we'll hear from him again on this issue. And I think that should be an incentive for folks to take this issue up and decide what they can do from where they stand. And I think that goes for people in politics and diplomacy and in the military as well.
I think that's certainly right, that the initiative is there. We just have to get people focused on the issue. I think for this panel, Audrey, you get the last word, and then I'll invite Dean Farrick if you'd like to make some final comments. Then I think Jonathan, John, and I would like to just say a couple very brief final comments, sort of reflecting on the day. And we'll go into our cocktail party, our virtual cocktail party, which is often very interesting. Audrey?
Thank you so much again, Charles. And, basically what we've been talking about here within the framework of, nuclear weapons treaties and laws, international laws, the International Criminal Court. So basically we are addressing, and I believe it was Jonathan who had mentioned the Universal Declaration of Human Rights. But the foundation of human rights is really based on an inherent recognition that life itself is sacred. And life has intrinsic value and deserves protection. So for any society to be just and stable, the rule of law must be properly promulgated and administered. And this speaks to the empowerment of the individual to have not only his basic needs met, but also to have the preservation and protection of his dignity and the free development of his personality, as Article 22 of the Universal Declaration of Human Rights has so beautifully expressed. So there's a free development of his potential. And Article 3 of the Universal Declaration of Human Rights indicates the right to life that we have and to live in freedom and safety. So the foundation of human rights comes from an inner knowing that we are inherently spiritual beings with spiritual purposes. And the laws that we create are a manifestation of that inner knowing, an externalized attempt of written codification. So to speak of what we have inherently known of ourselves as spiritual beings with truly spiritual purposes. So Article 1 of the Declaration of Human Rights recognizes that all human beings are endowed with reason and conscience and should act towards one another in a spirit of brotherhood and being in the family, the human family. And it also speaks to this conscience, but we ask the deeper question, where does conscience come from? And I would suggest to you that conscience arises from consciousness itself, which is a quality or state of being which is aware of what is taking place within oneself and all around us. And it is therefore simultaneously individual and universal in nature. And all of our conversation today, and this panel in particular, it really expresses a state of being which is aware, that tells us instantly whether our actions through thought, speech, or conduct creates a violation of ourselves or another, a violation that ultimately leads to our degradation and the degradation of another. And though we can try to rationalize our actions, the conscience is a repository of truth, which knows that no amount of rationalization can soothe the disquietude that sits within our hearts until that violation is cleared through a coherent alignment of the inner knowing with the outer conduct. So the essence of the spiritual and ethical dimensions of what we have been speaking about today in the context of law is ultimately based on an altruism that is unselfish and has regard for the welfare of others. And all the great spiritual teachers and ethicists from the beginning of the recorded human existence share that the highest potential to the fully developed human being is the one who has a heart of compassion, love, and caring for one another that not only makes human existence itself possible, but also makes it worthwhile. And as a great humanitarian and Nobel recipient Albert Schweitzer said, until mankind can extend the circle of his compassion to include all living things, he will never himself know peace. So thank you.
Thank you, Audrey. That is a lot to meditate on, and I think we're all going to play the link to this program more than once and watch it. Before I asked Dean Ferrick for any closing comments, I'm going to ask Laurie if you've had any thoughts as you listen to all this of further litigation, and equally important, are you a contact for anybody who wants to get involved in litigation in this realm? Are you still muted?
Got it. Yes, I am a contact for folks who want to be involved in litigation. One thought did occur to me while I was listening to Tom Colina and his optimism with the Biden administration, which I want to share that optimism. Is a quote of Barack Obama's when he was quoting Roosevelt, I believe it was, with regard to weapons-related issues. And it goes something like this. I agree with you. I want to do it. Now make me do it. And litigation can fill the role of leaning on leaders that agree with us, but need more reasons to get it done because of how strong the lobbyists, the defense contractors, the military complex in general. And so that's where I see litigation, and you guys know where to find me.
Thank you, Laurie. Dean Ferrick.
Well, I've made 3 pages of notes listening to the conversations, and I'm just overwhelmed and inspired by each of you in terms of the example you have given in your own lives, and your focus on this particular subject, which has not really been part of my background. I lead a center at Fordham Law School called Center for Social Justice, and we are very heavily involved in immigration issues, and we played a very significant role in Dilley, Texas, in terms of the political asylum issues. The Jesuit Refugee Service gave us the national award for work that the center is doing. So those are sort of the areas of my own involvement. But I made notes to have communications with different individuals at Fordham. Karen Greenberg, our national security center, to talk to her about this issue. We have a wonderful human rights program headed up by Marty Flaherty, who's very, very well known in the field of human rights. I'm going to encourage his center to focus on these issues. And I do have a very close relationship with Father McShane, who's the president of Fordham University. And I'm going to ask him the question, why aren't we involved as a university with Georgetown, Catholic, Notre Dame, and whoever else is involved? And Father might say to me, John, this is not your background. I said, but I know people like Charlie Moxley, who can be a Fordham College graduate, who can be very helpful. So I promise you I'm going to do what I've just said, because I didn't expect to end up with work tonight, because I'm just going to get started on it tonight in terms of communications. That's the way I work. So you're all terrific, and you educated me, you inspired me, and I'm gonna act on that. Thank you.
Thank you so much, Dean. Let's now just take, just a few minutes for each of us. Maybe John, Jonathan, I'd like to do it. Maybe Ed, if you would like to just say some very brief reflections. we're standing between us and the cocktail party, but it has been a wonderful experience. And so let's just each briefly reflect a little on what we come away with today. John?
Well, I'd like to say on behalf of Ariana Smith and myself that I hope the participants learned something today and were inspired today. And I'll just repeat what I said a few moments ago, which is if you're interested in activism in relation to legal issues we've discussed today, please get in touch with us at contact@lcnp.org.
Thank you. Jonathan?
I was very struck by Governor Brown's emphasis on planetary realism. That since time immemorial, the wise have admonished us to see the reality of the human family as one, as a precondition for becoming fully human. You know, the very famous Sufi poet Sadi said, "Oh, the human family is as one body. An injury to one part, a disease causes a healing response from the whole. Oh, you who don't feel the suffering of others, how can you call yourselves fully human?" This assertion of compassion and human unity, the wise have all been telling us, and the universality of the golden rule. This moral imperative at this moment in our lives has become a practical necessity to address protecting the climate, addressing pandemic diseases, and the horrific threat of nuclear weapons hanging over our heads requires a global understanding. And that global understanding is a mere sentiment unless it has the traction of law. And so I reach out to my colleagues in the bar and say, it's our job to translate that human sentiment into practical reality. As Jane Goodall, I recently did a dialogue with Jane Goodall, said, our future, peace or pieces. And Jane's admonition, one of the great wise people of our time, is consistently, you have to go on the journey from the head to the heart. And then we said, but now we have to go the head, the heart to the hand. And that's what's before us. And that's what we've heard all day. There are tools in the law. We need to learn them well and use them well. And I really thank Ed and Charlie and John and Kara and Simone for the hard work of bringing this together and making this a day in which I didn't feel uncomfortable sitting for, 8 hours. God bless you. Thank you.
Thank you, Jonathan. Ed, would you like to make any final concluding reflections?
Yes, I just want to thank everyone involved in this, speakers and the folks who were in the audience, the virtual audience, and especially Kara and Simone for making this a great conference and one that I think will, as it's being recorded, serve as an educational tool that we can use at colleges and even high schools to basically spread the word about what we were talking about today.
Thank you, Ed. I think the points that stand out most in my mind are twofold, maybe threefold. One, it is gratifying, and it was evident back at the time of the ICJ case that the U.S. acknowledged, and the other nuclear weapons countries and countries around the world broadly recognize that the law of armed conflict applies to nuclear weapons. And I think a lot of us felt that we had done a lot of what we were interested in doing with getting that realization over the years. I mean, even after the ICJ decision, that, well, it's a good point. And a lot of us wrote books and articles about this law applies and the US agrees that it applies. But I no longer feel that that's adequate, because it was evident from today that while the articulation of what the rule is And this came from the Red Cross, Kathleen Lewand. I'm not sure if you're still here. The statements of the rules by the Red Cross and by the US military in the manuals, it's the same statement. The rules are stated the same. The flaw is in the application. And the US approach, and it's for others to judge the matter, but my sense of it is that it is absolutely necessary under the rules as formulated, even by the US, as well as across the board in international law, that all the potential effects need to be taken into consideration. And you have to consider them. You can't just say, can we hit the target? And you have to look at the whole range, including into nuclear winter. And even beyond that, you have to do risk analysis, which comes down to the question on any given use of nuclear weapons, certainly between the major states, is it not likely you're going to have an escalation and you're going to have a percentage? And one would have to estimate the number. But once that point is accepted, and I think it's a point that can't be avoided, that with any use of nuclear weapons between a major power, and even between India and Pakistan, that there is a chance that it will get out of hand, then you have to put a value on that. And since the legal analysis has to be made in advance, you can't help avoiding the question, what does the law require of a probability, even if it's low, of a high impact result? And I have to tell you, even in, and you can find this on, you can Google this in no time at all, even in the US Joint Chief of Staff's doctrine on joint risk analysis, the nuclear weapons risks are characterized as existential. And we know what that means. So I think that's the first point I want to make, that we have to get to refining the issues as to the application of this body of law. We have to communicate it. I thought that what Scott Sagan said is so good. We need to get the JAG people at the next one of these conferences, which hopefully we will do soon. We need to get a dialogue going because, that's the second point I wanted to make, is that the points Ambassador Ford made, I'm sure were made in complete good faith, and he believes them. The thing that I personally, just speaking for myself, but I think from listening to everybody, listening to a lot of people, the sense that, well, the potential enemies are bad and they're doing bad things, and so we just have to be ready to deal with them, and they don't have civil society and we have civil society. What is missing there is that the United States is, or has the potential to be, it isn't now, the world leader. We can change things. We can take what Governor Brown said, maybe not to the extent he took it of the visionary nature, but we can take a good part of it. We can influence this. We're not even trying. We're not trying to avoid launch on warning. Maybe Tom Kalina is telling us, and I thought that was wonderful, that there is a potential to get the land-based ICBMs, which we've had, the triad, land, sea, and air, because that is so volatile, because you get a report that there's an incoming attack, but so often there hasn't been, and we've always avoided acting on it. So there's so much room for creative thinking. I think the one point Ambassador Ford made, I had that same concern even with the Obama nuclear posture review. That nuclear posture review said, abolition is our objective, and it was put into the indefinite future, which is inappropriate as a matter of law for reasons we've heard today because of Article 6. But that nuclear posture review said the same thing. Abolition is going to mean that you're going to have all the nuclear power countries and other near nuclear countries ready to become nuclear at the drop of a hat. And, is that inevitable? Does that have to be the case? Can that something be done? The ability to have intelligence and surveillance has greatly improved. And so we don't have to accept the lack of options other than the military options. So I'm going to stop, and I'm going to ask Simona to take over from the State Bar and tell us how we're organized for the breakout. But before I do that, let me just reiterate what Ed and Jonathan said. I mean, we're so grateful to the State Bar. We're so grateful to the ABA. We're so grateful to Fordham. One of the first things I did when we had the thought of this program is I reached out to Dean Farrick, and he was behind it right away. And Jonathan knew Father Drew at Georgetown, who quickly joined us, and all these other, wonderful co-sponsors, the City Bar, New York County Lawyers, the LCNP, Global Security. It's the support we've had, we're so grateful for. And this whole Zoom thing, we saw what could happen, and we were back up in 6 minutes. So thank you, Ed and the State Bar people and Simona, and I think Kara's off probably on another webinar right now.